Mine is.
How's that? Good.
Yeah, there you go.
Okay, all right. Here we go again. The Rules Committee will come to order. So we have a busy day in front of us, and I will go through the items on our agenda as they will be considered today. First, we will consider H.R. 2062. This is a bill in response to a 2009 Supreme Court ruling that made it harder for older Americans to prove discrimination in the workplace. This legislation will restore workplace protections while paving the way for a more inclusive and diverse workforce. Second, we will consider S.J. Res. 13. This disapproves of a rule finalized in the waning days of the Trump administration that goes against a 2015 Supreme Court ruling and stacks the deck against those seeking justice after experiencing workplace discrimination. Third, we will consider H.J. Res. 14, which invalidates Trump-era rulemaking and restores the robust methane pollution standards that were established in 2016. This is a measure that passed the Senate with bipartisan support, and this House must now send this critical legislation to President Biden's desk for his signature. Fourth, we're going to consider S.J. Res. 15 to overturn a Trump administration rule that made it easier for predatory lenders to take advantage of Americans in need. The final two items on our agenda today will be included in this rule, though we won't be hearing testimony since they'd already been debated on the House floor. H.R. 1443, legislation to promote fair lending for LGBTQ business owners and strengthen our economy as a whole. I was disappointed that 117 Republican members prevented this uncontroversial bill from passing under suspension last week and during Pride Month. And H.R. 239, a bill that ensures equal access to contraception for our veterans. I will note that women represent the fastest-growing subpopulation of veterans in the nation. This bipartisan legislation passed the House by voice vote last Congress. I don't know what in the world has changed since then, but to me this bill is as common sense and necessary today as it was then. So we need to finally get this done. And with that, I'm going to turn it over to our ranking member for any opening comments he has.
Thank you, Mr. Chairman. Today's hearing covers 4 items. The first I'll discuss is H.R. 2062, Protecting Older Americans Against Discrimination Act. This bill will be familiar to our returning members since we considered it just last year. As the committee will recall, this bill changes the burden of proof in age discrimination cases arising under the Age Discrimination in Employment Act. It's intended to overturn a Supreme Court case called Gross versus FBL Financial Services and allows the plaintiffs in age discrimination cases to recover if they can show that any practice by an employer for which age was a motivating factor is covered by the Act. Well, I think every member of the House would agree that age discrimination is abhorrent. The data fails to make the case that age discrimination is as pervasive as Democrats claim. Age discrimination is already against the law, and the legislation before us today would only contribute to the filing of frivolous claims, making it take even longer for justice to be served in cases of actual age discrimination. Our remaining 3 items are all resolutions arising under the Congressional Review Act. In each case, the majority is seeking to use the CRA to overturn Trump-era regulations. In each case, passage of these resolutions and a signature by the President will mean that each of these agencies will be barred from ever issuing a substantially similar regulation in the future. The first of these 3, S.J. Res. 13, overturns the Equal Employment Opportunity Commission's rule on conciliation. Conciliation is a procedure required by law under which the EEOC works with a complaining employee and their employer in an attempt to resolve the dispute without resorting to litigation. Prior to issuing the regulation, the EEOC had not updated their conciliation procedures since 1977. As with much of what the majority has done over the last 2 years, the only true beneficiary to this resolution is trial lawyers. Conciliation is a useful mechanism that helps people resolve disputes outside of litigation. If we discourage conciliation, as will be the case if this CRA passes, the end result will be greater and greater levels of litigation. That's not always helpful to either the employee or the employer, but it will be helpful to trial lawyers who would stand to collect greater legal fees if this joint resolution becomes law. The second resolution, joint resolution, S.J. Res. 14, overturns an Environmental Protection Agency regulation concerning methane emissions from oil and natural gas producers. This particular item will be devastating for my district and my home state of Oklahoma should it be signed into law. In 2020, the EPA issued a new source performance standards regulation that rolled back onerous Obama-era regulations on emissions from oil and natural gas production sites, including methane. This regulation streamlined existing regulatory authorities, reduced duplicative regulations, and reduced burdens and the compliance costs for oil and natural gas producers. The clear effect of the 2020 regulation is to improve America's energy independence and to increase economic growth, particularly in America's heartland. For my home state of Oklahoma, increased oil and natural gas production over the past 2 decades has been a clear boon for the state, both for economic growth and for greater employment. Repealing this regulation, as the majority now is proposing to do, would snap back the onerous Obama-era regulations into place. This means greater costs for oil and gas, natural gas producers, which means fewer sites are developed and fewer people will be employed. All that's very bad news for Oklahoma and for Oklahomans, but it's also bad news for Americans as well, because it makes us less energy independent and frankly increases the cost of energy in heating and cooling homes for every American. Our final item, SJ Res 15, repeals an Office of Comptroller of the Currency Regulation that clarifies which bank is considered the, quote, true lender, unquote. When a national bank partners with a third party, the OCC regulation at issue clarifies that the lender that is named in the loan agreement or that funds the loan is considered the, quote, true lender, unquote. The regulation is intended to provide additional clarity in the market and to ensure that consumers can identify who they are doing business with when taking out a loan. Repealing this regulation seems to be contradictory to the goal the majority is purportedly attempting to achieve. By keeping this regulation in place, we would ensure that consumers could identify with whom they are doing business, and we could ensure that the financial regulators, including the OCC, could maintain robust supervision over the financial system. By repealing this, we run the risk of adding uncertainty and a lack of clarity back into the financial system. This is never a good thing for consumers and will limit their ability to know with whom and under what circumstances they are doing business. In their zeal to overturn regulations issued by the Trump administration, it seems to me that the majority is now throwing out the baby with the bathwater, and we would be better served to reject SJ Res 15 and allow this regulation to stand. With that, Mr. Chairman, I look forward to hearing from our witnesses today, and I yield back.
Thank you. The gentleman yields back. I thank you for his opening remarks. Now I'd like to welcome our witnesses to provide testimony on H.R. 2062, the Protecting Older Workers Against Discrimination Act, and S.J. Res. 13, providing for congressional disapproval of the rules submitted by the Equal Employment Opportunity Commission related to update of Commission's conciliation procedures. Chairman Scott and Ranking Member Fox, we're delighted that you are here. And I just want to, before you begin, ask unanimous consent to insert in the record Statement of Administration Policy on H.R. 2062. It says the President supports this bipartisan legislation that protects workers from age discrimination. With that, I now will turn to Chairman Scott.
Thank you, Mr. Chairman. Ranking Member Cole, members of the committee, I'm pleased to speak in support of H.R. 2062, the Protecting Older Workers Against Discrimination Act, and Senate Joint Resolution 13, the Congressional Review Act, resolution disapproving the Equal Employment Opportunities Commission conciliation rule. The first bill, the Protecting Older Workers Against Discrimination Act, which I previously co-led with our former colleague from Wisconsin, Jim Sensenbrenner, has been introduced this year with Rodney Davis from Illinois. This bipartisan bill addresses the Supreme Court's decision of the 2009 case of Gross versus FBL Financial Services, which set a significantly higher burden of proof for workers alleging discrimination due to age than the burden of proof for other forms of discrimination, such as sex, race, national origin, and religion. Under the Gross standard, workers must prove that age discrimination was the decisive cause behind an employer's action rather than one of the motivating factors. This is a needless barrier to justice for older Americans who have experienced record unemployment rates during the pandemic. Age discrimination also holds back our economy. Research by AARP and the Economist Intelligence Unit found that absent age discrimination, older workers would have contributed $850 billion more in 2018 to the gross national product. And so our labor market and our economy cannot fully recover if we fail to support our older workers. Protecting older workers against discrimination, the Protecting Older Workers Against Discrimination Act restores the pre-2009 burden of proof for age discrimination and aligns this evidentiary standard with the same standard for discrimination claims based on sex, race, religion, and national origin. It also reinstates the standard for the Americans with Disabilities Act, the Rehabilitation Act of 1973, and the anti-retaliation provisions of the Civil Rights Act of 1964, which have all been impacted by the logic used in the Gross decision. And today, some of our colleagues have argued that the Gross decision has not discouraged workers from filing age discrimination claims. However, the reality is that due to the higher evidentiary standard, many of these cases are automatically dismissed. This is precisely what happened to Jack Gross, who won his age discrimination case at the district court level under the existing mixed motive standard. However, after the Supreme Court changed the rules and required him to retry his case under the higher but-for standard, he lost, despite having proven the same facts with the same parties in the same courts as before. In 2019, 227 Democrats and 34 House Republicans voted in favor of Protecting Older Workers Against Discrimination Act, and I hope we can come together again to reaffirm our bipartisan support for older workers. Second bill is the Congressional Review Act Resolution of Disapproval, SJ Res 33. 13, that nullifies the EEOC's conciliation rule. This resolution is identical to the resolution I introduced with Ms. Bonamici, HJ Res 33. On January 7th, the EEOC issued a final rule that imposed onerous requirements in the conciliation process for employment discrimination claims. Title VII of the Civil Rights Act of 1964 requires that where the EEOC has reasonable cause to conclude that an employer has violated the law, it must engage in informal methods of conference, conciliation, and persuasion before it files a lawsuit. The new rule will put a thumb on the scale in favor of employers where the EEOC has found reasonable cause that the employer has violated federal civil rights laws. Under this rule, the EEOC must provide an employer with a written summary of the facts and non-privileged information the EEOC relied on to determine that the employer violated the law. The rule requires the EEOC to identify aggrieved workers or groups of workers for whom relief is being sought. For workers, the conciliation rule means delay in justice and an increased risk of retaliation against victims of discrimination and witnesses. The one-size-fits-all rule also conflicts with the Supreme Court's unanimous 2015 decision in Mock Mining versus EEOC, which held that the EEOC must have the discretion to use whatever informal means of settlement are appropriate in each case. At best, the new conciliation policy will delay justice for victims of discrimination. At worst, it will open the door for collateral litigation over whether or not the rule has been complied with, potentially adding years of additional litigation before ever reaching the merits of the discrimination claim. Civil rights leaders and worker advocates across the country have called on Congress to pass this Congressional Review Act a resolution of disapproval because they, as they say, justice delayed is justice denied. By enacting the resolution, we would restore the EEOC's previous practice of determining the best means of conciliation on a case-by-case basis. The Senate has already passed the resolution, and the administration, if they haven't already, will be issuing a statement of administration policy in support. Thank you, Mr. Chairman, and I yield back.
Thank you, Ranking Member Fox.
Thank you, Mr. Chairman, Ranking Member, and all of my friends on the Rules Committee for having me here today. I'm pleased that see these meetings are finally taking place in the Rules Committee hearing room. Unfortunately, Education and Labor Committee meetings are still being conducted completely in a virtual format, depriving our members of an important opportunity to work together in person. Reopening the Education and Labor Committee would also send an important message to students, teachers, business owners, and workers that committee members are now coming to work just like they are in schools and businesses around the country. Let me start my testimony by telling you why Education and Labor Committee Republicans reject the fatally flawed Protecting Older Workers Against Discrimination Act, or H.R. 2062. This defective legislation sailed through the committee process without serious review or consideration as to its need or its impact on workers and business owners. The only committee evaluation of the legislation this year was a subcommittee-level hearing discussing 4 completely different bills. Even then, the Democrats' own witness admitted that federal discrimination data does not support the need for this bill. There are many more pressing policies our committee and the House could be considering. Shuttered school led to significant student learning loss. The crisis at the border continues unabated. College costs continue to surge. There are over 9 million unfilled jobs available to qualified workers. The inflationary economy is putting basic consumer goods out of reach for middle-class Americans. But no, Democrats are fixated on solving a problem that doesn't exist. Age discrimination is already against the law, and this is as it should be. What's more, employment trends for older workers are positive in recent decades. In 2018, older workers earned 7% more than the median for all workers compared to 20 years ago, when older workers earned 23% less than the median for all workers. Despite these facts, Democrats are moving forward with flawed legislation that doesn't help the people it purports to help. H.R. 2062 allows mixed motive claims in age, retaliation, and disability cases. The legislation overturns Supreme Court precedent and allows a plaintiff to argue that age was only a motivating factor and not the decisive factor that led to the employer's adverse employment action, even though the employer had other legitimate reasons to take the action, such as job performance. Allowing mixed motive claims abandons congressional precedent, too. Congress has long and rightfully recognized that different forms of discrimination require different procedures and laws. In 1964, both the House and the Senate defeated amendments to add age discrimination to the Civil Rights Act. Instead, Congress created a separate law in 1967 to prohibit age discrimination, the Age Discrimination in Employment Act. Yet H.R. 2062 imposes the mixed motive standard across 4 very different non-discrimination laws. By doing so, this legislation goes far beyond addressing older workers in the workplace and mandates a one-size-fits-all scheme. This legislation isn't detrimental to businesses alone. H.R. 2062 simultaneously hurts workers and acts as a cash cow for trial lawyers. In most cases brought under the bill, the plaintiff will not receive damages, but the bill makes sure plaintiff attorneys get paid. Under this legislation, most employers will be able to demonstrate to the court that they would have taken the same employment action. When that happens, which will be the vast majority of cases, the plaintiff will not receive any recompense. Current law is better for workers. Today, when a plaintiff wins, he or she can receive damages, back pay, and reinstatement. In an astonishing twist to anyone who stopped studying the bill after reading its short title, H.R. 2062 will take valuable resources away from organizations' efforts to prevent harassment and discrimination. As the Supreme Court pointed out in the Nassar case in 2013, Court cases aren't cheap, and because business owners will be forced to spend money to litigate or settle the increase in frivolous trial lawyer instigated legal claims encouraged by the bill, few dollars will be available for other important priorities. Make no mistake, Republicans are opposed to any form of discrimination. I will fight for and support all effective workforce policies, but H.R. 2062 will not be effective for workers or employers. It's a misnamed bill which goes far beyond its declared purpose and a misguided payout to Democrat allies. The other legislation you're considering today is S.J. Res. 13. There are many reasons why the House of Representatives should celebrate and not object to a recent U.S. Equal Employment Opportunity Commission rule. I'm referring to the EEOC rule published earlier this year, which is often called the Conciliation Rule. S.J. Res. 13 is a partisan maneuver which overturns the eminently responsible regulation. I oppose S.J. Res. 13 and urge members from both sides of the aisle to join me. The rule provides fairness, transparency, and justice to all, promotes prompt and collaborative solutions over adversarial litigation, is budget neutral, and upholds the statutory obligations of the EEOC. The Civil Rights Act of 1964 requires conciliation. Before the EEOC can pursue court proceedings against an employer for a discrimination claim, the agency must work with the business to resolve the dispute. There are good reasons Congress established this requirement. Successful conciliations provide immediate relief to employees who have suffered discrimination. They also save these employees time, money, and peace of mind. Court cases are adversarial and can last years. Individuals who experience discrimination should not have to wait years for justice. Nothing in the regulation prohibits the EEOC from using the court system if conciliation fails. For over 4 decades, EEOC's conciliation process remained largely ineffectual and unchanged. Antiquated bureaucratic systems deserve scrutiny, and this opaque practice was long overdue for improvement. Prior to the rule's promulgation, a paltry 41% of conciliations were successful. 1 out of every 3 employers declined to participate in this broken process. In 2015, the Supreme Court reprimanded the EEOC for its inadequate process, which included failing to communicate to employers basic information about the alleged discrimination. The clear evidence that something must be done to recalibrate the conciliation process grew harder and harder for the EEOC to ignore. That is why the conciliation rule was issued on January 14, after an extensive notice and comment rulemaking. Under the rule, the core tenets of conciliation remain unchanged. It remains voluntary, does not favor either the employer or the worker, and protects individuals' privacy. The rule requires the EEOC provide employers with basic but important information in support of the agency's findings, including simple facts about the legal basis for the finding, an explanation of the monetary relief calculations, and whether the EEOC designated the case for a class of individuals. The rule also does not increase costs to taxpayers. EEOC is on the record saying its operating budget will absorb any minor cost associated with implementing the rule. If it becomes law, S.J. Res. 13 not only nullifies the rule, but prevents the EEOC from ever producing a similar rule in the future, as the ranking member has pointed out. Repealing the rule is imprudent, but it would be the height of congressional folly to block the agency from ever issuing another rule to correct the imbalances in the conciliation process. All things considered, S.J. Res. 13 harms the victims of discrimination, encourages the EEOC to pursue needless, combative, and expensive litigation, and turns the EEOC back into a politically driven runaway bureaucracy. As a former member of the Rules Committee, I also feel obligated to note for the record that EEOC's conciliation rule should not qualify as a rule under the Congressional Review Act, and therefore should not be subject to congressional disapproval pursuant to the CRA. The term rule, as defined in the CRA, excludes any rules relating to government agency management or procedures that do not substantially affect the rights of non-agency parties. Therefore, EEOC's rule should not qualify as a CRA rule because it relates to agency procedures and does not convey rights to non-agency parties. Furthermore, when the EEOC submitted the final rule to Congress, the agency stated it is not a rule under the CRA, but that the EEOC was submitting the rule as a courtesy. Mr. Chairman, thank you for the opportunity to testify before the committee today. For all the reasons I've just described, I ask my colleagues to oppose both H.R. 2062 and S.J. Res. 13. I'm happy to answer any questions you may have.
Well, thank you very much, Ms. Fox. We appreciate your testimony. And as eloquent as you were, I agree with Chairman Scott more than I agree with you. So I'm with him, and I have no questions. I turn to Mr. Cole.
I'm shocked, Mr. Chairman, shocked.
Well, I found your eloquence unsurpassed. Chairman Scott, under the CRA process, should this resolution pass, it would prevent the EEOC from any further rulemaking on conciliation. Is that correct?
If the resolution passes, you would be subject to the mock mining case, which gave them the discretion that they need.
Well, for a regulation that hasn't been updated since the Carter administration, seems to me there's a clear need for this update. Are you confident, Mr. Chairman, that the system currently in place is working as intended? And do you not believe that after 40 years there's room for additional transparency and expediency that this rule provides?
Well, we have to get rid of this rule. It requires the EEOC to expose witnesses to retaliation, extends the process, and the distinguished ranking member said that it hurts victims. Well, the victims and advocates for victims are the ones that are asking us to pass this Congressional Review Act to throw the rule out.
Ranking Member Scott, do you agree with that assessment? Or, excuse me, I guess I was just dreaming there for a minute. I'm sorry, Ranking Member Fox,
Yeah, but that's okay.
do you agree
It's
with that
okay.
assessment?
It's all right. It's quite all right. We're not yet joined at the hips, but we're getting close. Well, no, I don't agree with it. Currently, conciliations are successful in only 41% of the cases where EEOC believes discriminations occurred, as I mentioned, and 1/3 of employers declined to participate at all. So as you said, we really think that it's time for an upgrade. In 2009, an Iowa federal judge accused the EEOC of taking a sue first, ask questions later approach to enforcement. In 2015, the Supreme Court harshly criticized the EEOC's conciliation process as inadequate in the mock mining decision. We really believe that this fixes the conciliation process. It enhances fairness, transparency by providing the employer basic factual and legal information, avoiding expensive and time-consuming litigation, ensuring the EEOC honors its statutory obligation to engage in good faith conciliation before filing lawsuits. We don't think Congress should nullify this rule for lots of reasons.
Well, Dr. Fox, just to be clear, age discrimination is already illegal, and Congress has enacted laws to that effect. Is that correct?
Absolutely.
And Dr. Fox, do you think the law is not adequately protecting older workers?
Oh, I do. I think it is adequately protecting the workers. It was written specifically to address unique circumstances found in age discrimination cases. And the evidence indicates that ADEA has worked well by protecting older workers. EEOC data do not indicate workers have been discouraged from filing age discrimination charges with the agency since the Supreme Court's 2009 decision. In the 11 years since following Gross, there was actually a slight increase in age discrimination charges filed with the EEOC. In addition, age discrimination charges as a percentage of the charges filed at the EEOC are approximately the same for the 11 years before and after the Gross decision. So plaintiffs have continued winning age discrimination in courts since the Gross decision. It hasn't really affected them.
And then, just to go back to a point you made, I mean, I think you have to look at the practical impact of legislation over time. And as I recall in your testimony, you pointed out that in 1998, when the median wage for older workers was actually 77% of the median age of workers 16 and up, and now it's 7% higher. That's a pretty dramatic reversal.
Yeah, that is true. Let me give you some other statistics. Employment, according to Bureau of Labor Statistics, employment for workers aged 65 and older tripled from 1988 to 2018, while employment for younger workers grew by a third. The number of employed people aged 75 and older nearly quadrupled from 461,000 in 1988 to 1.8 million in 2018. And it's important to note that as the country continues to recover from COVID, BLS recently reported that job openings reached a record high of $9.3 million in April of this year. And hiring is lagging far behind. We all know that. I'm sure everybody in here is being told about the job openings in their district. Everybody's looking for workers, and we're really, really worried about this increasing litigation and harming employers who are trying to bring more people to work.
Last question, Dr. Fox, and I think you've answered this, but I want to nail it down for the record. By passing H.R. 2062 to overturn what you and I both believe are pretty effective Supreme Court precedents, do you think it might ultimately do more harm than good?
I do, because the employees just are unlikely to gain any damages as a result of it. It's mostly going to go to the trial lawyers.
Thank you. I see my friend, the chairman, has left, so I'm assuming I'm going to yield to Madam Chairman.
Thank you, Ranking Member. I would recognize myself for comments. Thank you both for being here today. Really appreciate your testimony. I think, the reality of today's job market is that seniors many of them have had to return to work. Unfortunate circumstances. We have the opioid crisis. Seniors have had to take on roles that they've never had in the past, including caring for their grandchildren, their children's children. While they should be enjoying retirement, it has been a true necessity for them to have to come out of retirement and go back to work. So, have you heard of the term blacklisted, Ms. Fox?
Well, yes. Over the years, I've heard that term many times. I'm not sure how that...
I'm just asking you, general question. Thank you. Blacklisted is a real thing. And while I agree that in some types of jobs, CEOs, we are seeing more and more CEOs advance in age and have more opportunities to continue to keep their jobs. However, that's not the case for frontline workers per se. Many of them are forbidden. It's the unwritten forbidden issue of having to complain, much less file a complaint against an employer because they are being discriminated, passed on for a promotion, passed on for a job raise, simply because of their age. There are certain industries also that don't want their workforce to look like you and I, older in age, but still young at heart, as I know you are. So, those are some real concerns that I hear from my constituents. Before this pandemic, many of the seniors that I represent were struggling. Their number one concern was, we have a right to work. We want to work. I've applied to 100 different jobs that I am overly qualified for, and I'm being denied work. I can't file a complaint because I will be blacklisted. I can't file a complaint because, where is my complaint going to go? And I am concerned that any opportunity that I may have for a job, maybe somewhere else, will be completely closed. For those reasons, I support HR 2062. And I want to turn over to Chairman Scott to provide us with some information that you may have, specifically related to what we are now looking at frontline workers and the role that seniors have had to take in those jobs.
Well, I want to respond to the idea that age discrimination is no longer a problem because older workers are being paid, according to that study, a little bit more than average. Of course, they're supposed to be paid more than average. They've got a lot more experience than average. I'd like to enter into the record a letter from the AARP and just read a little bit of it. It says that 78% of older workers reported as having seen or experienced age discrimination in the workplace in 2020, markedly up from 61% in 2018. That's from 61% to 78%. More than half of older workers are forced out of the job before they intend to retire. 9 out of 10 of those who do find work never again match their prior earnings. Making matters worse, the COVID-19 pandemic has significantly diminished the job prospects and future retirement security of older workers. In April, over half the job seekers age 55 or older continued to be long-term unemployed, 53.3%, compared to 42.3% of job seekers age 16 to 54. Labor force participation rates for older women workers, along with their earning power and future retirement security, have been particularly hard hit by the COVID pandemic. So we have a problem. It's getting worse, and it is particularly bad for older workers because they're going to have trouble because of discrimination getting another job.
A specific case with one of my constituents comes to mind. His daughter had a baby, and she had a lot of health issues related to it. He took 4 weeks off from work to care for his daughter and his grandbaby. Unfortunately, his employer told him to choose between continuing to work and caring for his grandchild. The choice at the end after he left his job was very clear. It wasn't that the employer was denying him time off. It was really, the purpose was that the employer wanted to replace him with a younger, what he thought was faster, worker, which is really unfortunate. My constituent decided not to file charges or complaint, and instead he quietly was forced into retirement. No one should be forced into retirement simply because they are being discriminated against. So thank you for your comments. Thank you for being here again, my dear friend, Ms. Fox. I will now yield to Mr. Burgess.
Thank you. And Chairman Scott, I was wondering if you could just clarify for me. We have heard the assertion made that this is a bill to empower trial lawyers by encouraging lawsuits. without their ability to seek monetary relief for the discriminated parties. How is that an assertion of this, this bill
Well,
2062?
we hear claims that every right you give someone to bring a lawsuit only helps trial lawyers, makes about as much sense as Medicare is only good for doctors and hospitals.
Well, no, it's been crummy for doctors and hospitals, but
Well,
proceed.
But the lawyers are providing a service. If you want to get rid of legal fees, stop discriminating.
But are lawyers allowed to seek monetary relief on behalf of their clients under 2062?
Yes. If you bring a discrimination claim, if you prove your case, you can get back pay and other damages. Just like, and what it's doing is aligning it with the same rights and privileges you have in a case on racial discrimination, sex discrimination, religious, national origin. You get the same kind of damages.
So Ranking Member Fox, it seems a little bit at odds at what I heard your testimony to be. Can you help me with the discrepancy there?
Well, the way we believe that it's written, it will not do that. And
It will not.
it will not allow, it won't give most of the money to the plaintiff. It will give the money to the lawyers.
So the injured party would not be the beneficiary of a judgment. And why is it written that way?
Well, that's a puzzle to us, but in the most cases, it's because so much of the legislation written around here is a real gift to trial lawyers. And we think this is one of those.
Yeah, I was just
Well,
troubled by the language in the bill.
Just for the record, we don't believe it's written that way. It's written that way. If you have discriminated, you can get compensation, just like you can in other cases. And if a lawyer is making a fee for the services that he provides, that's, how else are you going to get a lawyer to represent you?
Well, it's just interesting that there should be such a stark disagreement. But maybe not interesting, but not surprising. Is it that lawyers are going to be able to combat discrimination, age discrimination in the workplace better than?
If somebody has a case, an allegation of age discrimination, and they hire a lawyer, and the lawyer represents them and wins the case, they can get legal fees.
But then how is it different now? Existing protections under the law, that would still allow that to happen,
That's
would it
right,
not?
but except you can't win the case if you are under this higher standard. In age discrimination now.
Current
in age-
law is a higher standard, is that what you're telling me?
The Gross decision established a higher standard of proof for an age discrimination case than race, religion, sex, national origin. The difference is that you have to prove that it's called but for age, you would not have been, you would not have had adverse action taken, as opposed to what's called mixed motive. If you can prove that age was a motivating factor, it said, you're too old to be here, you're fired. And then you have to prove that you would not have been fired if you weren't if you weren't over 40 years old. How do you prove a negative? You don't have to do that in a race case. It says, I don't like black people, you're black, you're fired. Well, that's the case. I mean, that's all you have to prove. Why do you have to prove more in an age discrimination case?
Let me ask Ranking Member Fox that question. Why is the standard of proof higher in an age discrimination case?
Well, I am not an attorney, so I don't have the finer points on this, but my understanding is that it's the opposite of the way the chairman is describing it. They go back to the mixed motive way And because of that, they are not always able to get the damages paid to them. That's my understanding.
So then that would come back down to the monetary relief for lawyers and not for the patient, or not for the discriminatee.
And there's another little twist to this in the way the bill's written, is that the employee might have to pay income taxes on the fees that are awarded to the attorney.
We've heard that allegation, and we don't agree with that assessment either.
I guess further litigation pending. Thank you both for being here today. I'll yield back.
Gentleman yields back. Mr. Perlmutter.
So, Mr. Scott, just on this attorney fees thing, in this bill, does the lawyer have to prevail to get any attorney's fees and the back pay and all that stuff?
Yes,
Okay, so they have to prove discrimination.
yes.
So to your point, if you wanted to eliminate the attorney's fees, don't discriminate.
Hello.
Thank you. I yield back.
Gentleman yields back. Mr. Reschenthaler, you're recognized.
Thank you, Madam Chair. I appreciate it. And just so you know, Chairman Scott, I looked it up, looked your district up. I did live in your district for 2 years when I was in the Navy. So next time I'm in Norfolk, I'm taking you to Kogan's Pizza. We're going to have a blast. You might have to help me clear some bench warrants that are still out. I'm kidding. I'm kidding.
But you will get attorney's fees.
That's
for
right.
doing
Yes. No, okay. Oh, in all seriousness, Ranking Member Fox, can you just help me clarify the EOC conciliation rule and how, if we repeal that, how will that impact victims?
How it impacts states.
Right. Well, what will it do with discrimination in the workplace if we repeal the EOC conciliation rule? What kind of impact will you? I'm still a little fuzzy on that.
As I said before, it's very difficult right now for employers to go through with the conciliation because they don't have anything to go on at the very beginning and they refuse to do it. We think it's the way to go because you can get through. Almost everything now in law is requiring conciliation. Almost any kind of case that comes up is requiring conciliation. And if they don't do this, then it's going to drag it out, cost people a lot of money, a lot of heartache, and not be the way to solve a lot of things because they could solve a lot of the cases. The other thing is, as the ranking member pointed out, and I pointed out too, it would keep the EEOC from ever coming up with another conciliation law because of the way the CRA is written. And that's very, very damaging since these rules haven't been changed in so long.
Thank you, Ranking Member. And just to bring this line of questioning full circle, the ice cream cone was invented in the chairman's district. And Dr. Burgess, it was invented by a lawyer. All right, with that, I yield.
The gentleman yields. I assume we like ice cream. Mr. Raskin, you're recognized.
That's one good thing a lawyer's done.
Well, the Republican Party was founded by Abraham Lincoln, who is a great lawyer. So let me pursue this point about lawyers for a second, because, you know, it seems to me that one person's frivolous litigation is another person's civil rights lawsuit, an opportunity to get justice. The last president brought 62 cases in federal and state court alleging violation of voting rights and his right to run for office by different abridgments of his civil rights and civil liberties. And he had every right to do so. And he used millions of dollars of his supporters' money to do it. And they asked for legal fees in most of those cases. Now, they lost all those cases. They were all thrown out as baseless and meritless and so on. But would anybody say he should not have had the right to bring those suits and to ask for lawyers' fees for violating his rights and the rights of the voters in the states that he alleged were abridged? I don't think so. I mean, I think that's how our justice system works. People have a right to do it. Now, somebody could say, well, they wasted millions of dollars. That was his right to waste millions of dollars, and the right of his supporters to put that money into those suits. And they had the right to ask for damages, but they lost in court, so they didn't get the damages. That, I think, was Mr. Perlmutter's point. You only get legal fees if you win, if you're able to prove that your civil rights have been violated. So, Mr. Scott, I want to come to you about this whole mixed motive thing, because I think we need to slow down and really explain this to people. Okay, you're telling me that in a race discrimination lawsuit, if a plaintiff comes in and says, I was told I didn't get that job because they didn't like my race or my ethnicity or my religion, but they also said they didn't like my attitude, that's a case that the plaintiff is going to win because race discrimination or religious discrimination or ethnic discrimination has gone into it. It's some part of it. Is that right? Is that a mixed motive case?
If the employer can show that you wouldn't have gotten the job anyway, you lose.
But if the employer says, no, it was
But
those...
the employer has to show that. If you've shown that
Yeah.
one of the motivating factors of you not getting the job was your race, then you've made a prima facie case. And he can come back and show, no, you wouldn't get, because of this, that, and the other, you didn't have the minimum qualifications for the job, then he wins.
Okay. Now, there are a lot of older people who are getting back
But
into...
you don't have to show, once you've shown that race was a motivating factor, that's all you have to prove. If
Yeah.
the employer comes back and proves that you wouldn't have gotten the job anyway, he can win with the affirmative defense.
If the employer is able to show you wouldn't have gotten this job regardless, we didn't need to mention race. You found some emails mentioning race, but that was irrelevant to it. You wouldn't have gotten, the employer wins. But if a court says, no, race was a motivating factor, you would have gotten that job otherwise, then the plaintiff is going to win, right? Now, a senior who's bringing a similar lawsuit just wants to have that same right, so that if an employer says, well, you're really too old for working here and being part of this company, and also you live too far away and we don't think you can really get to work on time, or you're too old and we think you seem kind of sleepy, or something like that. And the jury would find, if the facts would support it, that age was a motivating factor, then most people would say that person should win if it was a motivating factor. But that's not what the law is now, right?
That's right. Well, the employer, if that's all the evidence, then the jury has to find the negative. I mean, you're asking the plaintiff to prove a negative, that he would not have gotten the job, that he would have gotten the job but for age. Well, you don't know what's in the employer's mind. The employer can come up, and if he can prove that you wouldn't have gotten the job, then the employer wins. But that's an affirmative defense. The case you make, we have proven that age was a motivating factor in me not getting the job, or not getting the promotion, or getting fired. It was a motivating factor. That's all I need to show. Now, if he comes back and shows, no, I was gone anyway, then I lose.
Okay.
But don't make me prove everything else that's on his mind after I've proved that age was a motivating factor. That's all you have to prove in other cases.
The plaintiff can't perform brain surgery or heart
That's the
surgery
problem.
on the employer. But once it's been shown that your age is a motivating factor for discriminating against you, then you should be able to win. That's what I understand.
Well, you ought to be able to proceed with the case.
At least proceed with the case.
And then the employer has an opportunity to defend if he can. But if there's, you're in a situation where you have to prove that you would not have been, that you would have gotten the job but for age. And you have to go speculate for the employer doing the brain surgery. I don't know what was on his mind. I do know that age was a motivating factor.
And you've got to prove that
And I've
age was
got
a
to prove-
motivating
and
factor.
I proved it.
Right.
Now, if he's got something else on his mind, let him bring it forward. But that's not part of my burden of proof.
So you're saying let the field of age discrimination law operate the way that other parts of discrimination law operate. There's no reason why a plaintiff in an age discrimination lawsuit should have this extra burden of trying to show that the employer had no other valid reason.
Exactly.
Okay. Well, I mean, that strikes me as perfectly logical and what America needs. I hear from people all the time in my district who tell me they cannot get treated fairly in terms of being hired, or they're being fired because of their age, or they're being treated differently. And that is an impermissible form of discrimination against our people, and we got to get over that. So I yield back to you, Madam Chair.
Thank you. Ms. Fishbach, you are recognized.
Thank you, Madam Chair. And I feel a little inadequate following Mr. Reschenthaler and his one-liners. So, but I don't have anything that amusing. But I do want to associate myself with the comments of the ranking member. And I wanted to ask Ranking Member Fox if she had anything that she wanted to add to potentially the line of discussion that was going on.
No, I'm fine.
Okay. All right. I yield back.
So I miss Mr. Reschenthaler's one-liners.
But, Mr. Chair, I think he needs to bring ice cream.
Okay, well.
He introduced conclusive evidence that the ice cream cone was in fact invented in Norfolk, Virginia, at Dumars. There are others that claim it, but he just put that fact in the record, and it is
And its
beyond
relevance to two bills that we're talking about?
That's
Well, I don't want to get into that. All right, okay. Mr. Morelli. Any, Mr. Morelli?
Thank you, Mr. Chair. I appreciate the comments made by Mr. Raskin, which is where I was on this. When it relates to age discrimination, as I understand it, Mr. Chairman, if the previous standard was a key factor, age would be a key factor that you'd have to prove. Now, as I understand it, since 2009, it's a sole factor. Am I correct?
but for. It's called but for, and it's a motivating, called a motivating factor.
The new standard requires plaintiffs to prove that age discrimination was the decisive, determinative, but-for cause for any adverse employment action taken by the employer. The new sole factor test replaced decades of precedent, allowing you to prove that it was a key factor.
Right.
So I guess I'm just curious of the ranking members, it relates to all the other forms of discrimination. Were they, in your judgment, the standard, which we're trying to make age discrimination in line with those standards, are those just bones to attorneys as well?
Well, I think what proves our point is what's happened since the Supreme Court decision, which is it hasn't slowed down people filing discrimination cases. It's the same as it was before. The 11 years before the Supreme Court and since then, there's been really no changes.
Well, I guess what I'm asking is, would you, if you had your druthers, roll back protections as it relates to workplace discrimination based on race, religion, sex, or national standard?
Of course not.
So you would have...
We haven't rolled back. There are laws that protect older workers. That's the point we were making. No, we don't want to roll back any kind of discrimination, any laws that protect people from being discriminated.
Well, it's, okay, so I think I'm having a problem with the logic. What I think, Mr. Chairman, you're suggesting is you'd like, by virtue of this change, we would make age discrimination on par with the other forms of discrimination as it comes to proof of whether that discrimination occurred. Is that right, Mr. Chairman?
That's the purpose of the bill.
So all I'm suggesting is if you don't agree with that, making age discrimination this standard, yet this standard would be the same as race, religion, et cetera, would you then argue, the ranking member, that the standards for those types of discrimination are out of line and that it ought to be the standard that you're suggesting should be for age discrimination? You understand the logic? I mean, you can't
Well,
have
no,
two
but
different standards.
The problem is that we're differing very much on the logic here. So, no, I don't want to roll back any discrimination laws, but we don't think this legislation does what you want, what you're saying it should do.
Well, I'll just say that I think putting this in line in terms of the factors that need to be present for you to prove age discrimination ought to be the same as it is for the other forms of discrimination. I think that's what the chair wants to do with this legislation. I think that's what this legislation does. And to suggest otherwise would suggest that perhaps lessening the standard for the other forms of discrimination would be in order, which I clearly would reject, and I think most people would reject as well. That's why I'll support the bill.
I think that's a leap of logic I would not agree with.
All right. Mr. Desagne?
I have nothing to add, Mr. Chairman. I yield back.
Thank you. Ms. Ross?
Thank you, Mr. Chairman. Just very briefly, I think that Mr. Scott has explained the bill about age discrimination exactly the right way. What happens is, if there are 2 reasons or 3 reasons that somebody's discriminated against, and you can show, for everything else except for age, you can show that one of the reasons was race or religion or whatever, the burden shifts to the employer to say that the predominant reason was something else. With age discrimination, even if there's some sham other reason that the employer comes up with, but the predominant reason was age, there's no burden shifting. There's no way that the person can keep going on with their claim. And this bill resolves that. It creates the same kind of burden shifting that we have in all the other areas, and it dissuades employers from coming up with pretexts for discrimination in order to throw out the case from the beginning. It's a great bill. It helps older Americans who are facing age discrimination more and more, and not only are losing their jobs, but losing their health care and losing their ability to support their families. So this is a terrific bill, and I thank Chairman Scott for bringing it to us. The second bill I think we should pass just because something came to us from the Senate. And if they can agree on it, and they can get bipartisan support, it's very, very important. And if you look at the bill summary, it's clear that the new rule, the one that we would be not going forward with, is one that would end up really burdening whistleblowers and people who comply with investigations and are retaliated against. And with that, Mr. Chairman, both of these bills are great, and I yield back.
Thank you very much. Mr. Neguse?
Thank you, Mr. Chairman. I have no questions. I certainly support both of the bills and would echo the comments made by Representative Ross and appreciate Chairman Scott for his leadership in bringing them forward. And with that, I yield back.
Thank you very much. Any other members? Anybody else? Mr. Scott?
Yeah, well, I regrettably have to correct the record on CRA.
Are you mic on? Yeah.
Yes. On the CRA, it is not subject to a filibuster, and I don't believe they got any Republican votes in the Senate.
All right. Yeah. All right, okay. All right. Anybody else, any questions? Seeing none, I thank both the chair and ranking member. You may leave. Are there anybody else wish to testify on HR 2062 or HJ Res 13? Seeing none, this closes the hearing on HR 2062 and SJ Res 13. Thank you very much. And now we are going to welcome our witnesses to provide testimony on HJ Res 14, providing for congressional disapproval of the rules submitted by the Environmental Protection Agency relating to oil and natural gas sector. We have Representative Peters and Representative Carter. I want to welcome you both. I now recognize the gentleman from California, Mr. Peters. Anything you've brought in writing you can submit for the record, but the floor is yours.
Thank you, Mr. Chairman.
Is your mic on? Yeah, okay.
It's on. There you go. Thank you. I'm here on behalf of the Energy and Commerce Committee to speak in support of the closed rule for SJ Res 14. a joint resolution providing for congressional disapproval of EPA's 2020 methane rescission rule, which removed direct federal limits on methane pollution from new and modified oil and gas facilities. Addressing methane pollution is one of the most important immediate actions we can take to combat the climate crisis. That's because methane is a superpollutant, more potent and harmful than CO2 by quite a bit, and is responsible for about 25% of the man-made warming we experience today. The greatest opportunity to curb methane in the next decade is in the oil and gas sector. That's one reason why reinstating the 2016 methane rule is so important. So today I have three key messages for the committee. One, methane pollution is accelerating the pace of climate change and harming the health of our families and communities. Without bold action to curb emissions from new and existing sources in the oil and gas sector, methane pollution will continue to cause significant harm to public health, threaten the stability of our economy, and compromise the well-being of future generations. Second, the Obama administration's 2016 methane rule set reasonable standards to address this pollution. The 2020 rescission rule dangerously and inexcusably abandoned that approach. Under the Clean Air Act, the EPA has an obligation to protect public health and welfare from dangerous climate pollution like methane. The 2016 methane rule required the oil and gas industry to take common sense steps like updating equipment and conducting frequent inspections to reduce methane pollution. The 2020 rescission rule abandoned that approach and established a rule that it increased methane emissions. Specifically, it eliminated methane standards across the entire oil and gas supply chain and revoked all federal air pollution limits for oil and gas transmission and storage facilities. Even more problematic, the rescission rule also purports to block EPA from ever controlling methane pollution from existing sources, which are responsible for the vast majority of the industry's pollution. Third, the 2020 rescission rule is a lose-lose-lose for climate, public health, and the industry. It should be disapproved by Congress. Enacting SJ Res 14 ensures that the 2020 rescission rule will have no force or effect, reinstates the methane pollution reduction requirements established under the Clean Air Act in 2016. Ambitiously addressing methane pollution can yield tremendous climate, public health, and financial benefits across the economy. It's why we see an outpouring of support from state and tribal officials, environmental and conservation groups, and many in the oil and gas industry itself in favor of this CRA. Simply put, this week, we in Congress can soundly reject one of the most irresponsible environmental rollbacks of the prior administration, maybe any administration, restore robust methane pollution standards, and clear a path for stronger protections in the future. The Senate passed this resolution of disapproval with bipartisan support on a vote of 52 to 42, and the President will sign the resolution into law once the House acts. If successful, this will be one of the most important climate actions of the last decade. It is our time to act. I thank the Rules Committee for bringing this important climate measure to the floor, and I look forward to answering any of your questions.
Thank you very much. Representative Carter.
Thank you, Mr. Chairman. Mr. Chairman, I appear here today on behalf of the House Energy and Commerce Committee Republicans to oppose SJ Res 14, a resolution of disapproval of important reforms to air regulations for oil and natural gas sources. SJ Res 14 has nothing to do with methane emissions or climate change. It's simply a partisan attempt to undo regulations issued by the Trump administration to clear the way for more aggressive mandates. In 2020, EPA issued two final rules to make it simpler and less burdensome to comply with their regulations for oil and natural gas sources. Combined, these rules were estimated to yield net benefits of up to $850 million by 2030. EPA's 2020 final rules corrected course by aligning with the requirements Congress established under the Clean Air Act and by relieving industry and consumers of burdensome overregulation. We oppose this unnecessary and misguided resolution because it will contribute to higher energy costs and reestablish burdensome regulations that were found to be unlawful under the Clean Air Act, in addition to being duplicate of existing regulations at the state and federal level. EPA's actions updated and corrected the Obama's EPA's national standards for the oil and natural gas industry. The Obama-era standards fell heavily on small and medium-sized energy businesses. Let me repeat that. The Obama-era standards fell heavily on small and medium-sized energy businesses. SJ Res 14 will roll back this progress and yet another attack on fossil energy workers. America's oil and gas industry supports nearly 10 million jobs and billions of dollars in economic development in all 50 states. But this resolution targets the same workers harmed by President Biden's cancellation of Keystone XL pipeline. Technological innovations and advances in hydraulic fracturing have made the U.S. the world's leading producer of oil and natural gas, and we are emerging as a major exporter. These are positive developments. As a result, we have strengthened our energy security and helped to revitalize our manufacturing industries. Contrast that success with what this resolution seeks to do. SJ Res 14 will reimpose regulations that were found to be unlawful under the Clean Air Act and redundant of existing regulations that already control for methane. In fact, this resolution will not reduce methane. This resolution will not reduce methane. EPA has found that existing pollution controls for volatile organic compounds also reduce methane emissions at the same time. Instead, SJ Res 14 will accelerate new methane regulations for other sources, regardless of their contribution to air pollution. This new regulatory trap could impact any of the more than 70 sources already exposed to EPA regulation under the Clean Air Act. Today, the U.S. is the largest producer of oil and gas and a global energy superpower. American companies are reducing emissions, innovating with new technology, and providing jobs and economic development to communities around the country. According to the EPA, methane emissions associated with natural gas and oil production declined by 23% by 1990. Meanwhile, Russia is attempting to strengthen its grip on European gas supplies with the construction of the state-sponsored Nord Stream 2 pipeline at the expense of American workers and U.S. LNG exports, which have 41% less life cycle GHGs than Russian gas. As President Biden waived sanctions on the Russian Nord Stream 2 pipeline, their choice is clear. Democrats are siding with Russia over American energy. Republicans on the Energy and Commerce Committee offered an amendment to express disapproval with the Russians' Nord Stream 2 pipeline, but Democrats rejected the amendment. The Biden administration's failure to stop the Nord Stream 2 pipeline and the majority's unwillingness to accept an amendment that would disapprove of Russia's tightening grip on European gas supplies ultimately comes at the expense of American interests. Republicans are focused on ways to strengthen America's energy security, lower prices for consumers, and reduce regulatory burdens. SJ Res 14 takes the opposite approach, and for these reasons, we oppose this resolution, and I yield back.
Thank you. I have no questions. Mr. Cole.
Thank you, Mr. Chairman. Mr. Carter, as you pointed out, from oil and gas production to processing, source emissions on methane are already regulated by the EPA, already regulated, frankly, by multiple state authorities. I know my own state, Oklahoma Corporation Commission, regulates these matters. We think does a very good job at it. If multiple levels of regulation of methane emissions are already being implemented, how necessary is this resolution in the first place?
Representative Cole, you're exactly right. This would, and you're correct in saying that there are multiple levels of regulation already in place, and we know that. We understand that. Methane emissions are already effectively regulated by EPA and by the states, as you point out, under the framework for controlling emissions of volatile organic compounds. EPA found that required volatile organic compounds pollution controls also reduce methane emissions at the same time, making clear that separate regulation of methane established no additional health protections and is thus unnecessary.
Well, during the markup of this legislation on June 10th, I understand that Representative Armstrong, North Dakota, highlighted that many of the larger oil companies that have submitted letters of support for this resolution are European or internationally based companies, meaning that most of their production would not be impacted by these regulations at all. Meanwhile, the smaller, independently owned American companies have not expressed the result due to the duplicative nature, and they're the ones most at risk. So again, given that, aren't we effectively undermining our own energy independence and assisting other companies and countries that aren't operating by the same rule?
Absolutely. There's no question about that. And that's what's so frustrating about this administration's approach to energy. I mean, I recognize that many of you aren't as old as I am, but I can still remember the late 70s.
Unfortunately, some of us are older
Some of
than
them
you
are, yes, but for those of you who
I
don't
could name
remember.
names, but I won't.
Yeah, I understand. You can't remember the late 70s. Well, you know, my point is this. Look, we recognized, I've always said there's a difference in knowing something and recognizing something and realizing it. We knew back in that time that we were too dependent on the Middle East for our energy needs. We knew that we needed to get energy independence. We realized it in the late 70s, and we did that. We achieved energy independence, but this administration seems to be intent on destroying that. This is going to hurt American competitiveness. It put unnecessary regulations on an industry that's already made significant progress in reducing their own emissions. I have to tell you that I'm proud of what the oil and gas sector in the United States has done. I mean, you talk about climate change, and I serve on the Select Committee for Climate Change. You don't realize that the United States of America, over the last decade, has decreased our carbon emissions more than the next 12 countries combined, while growing our economy. And a lot of that has to do with the progress that's been made in the oil and gas industry. So you're absolutely right. It would harm our competitiveness.
Last question, and to me this is an important issue because I think a lot of the regulatory thrust of the administration is more theology than science, frankly. But in a statement of administration policy that was released on the resolution in the Senate, the Biden administration stated that this CRA, quote, will clear the way for EPA to evaluate opportunities to promulgate even stronger standards under its auspices. So if the resolution were to pass, what other sectors of American industry would be impacted by burdensome resolutions?
Well, the fear is that the regulations expand to over 70-plus other categories that the EPA regulates that span across a wide variety of sectors, including agriculture. Look, the American farmer feeds the world. We need to recognize that. We need to recognize, and I get so frustrated with this because forestry and agriculture are not part of the problem with climate change. They're part of the solution. We need to recognize that. We are putting more pressure on them by doing this. We are penalizing them even more. We need to wake up and recognize what's going on here. This would have serious repercussions for Americans, no question about it.
Thank you. Yield back, Mr. Chairman.
Thank you, Ms. Torres.
I support this resolution. I think all we have to do is look back to the Trump administration and how irresponsibly the emission standards were gutted during that time. With that, Mr. Chairman, to ask for more inspections and to ask for some basic standards isn't too much of an ask, and I support this resolution. I yield back.
Thank you. Dr. Burgess.
Thank you, Mr. Chairman, and I would just reiterate what has been made by Mr. Cole and Mr. Carter, that there are abundant standards with which companies are required to comply each and every day. And it's also interesting that when you look, when I came to Congress in 2003, the country was running out of natural gas. I don't know if people remember that or not. We were tasked with figuring out ways to import gas from the North Sea because our chemistry manufacturers didn't have enough natural gas as feedstock. Our farmers didn't have enough natural gas to create the fertilizer products that they required. And then things changed. They changed in a relatively short period of time, and it was hydraulic fracturing and, again, policies that came through the Energy and Commerce Committee that allowed for natural gas abundance. And that, in turn, has led to the replacement of many coal-fired facilities with natural gas facilities, and that has resulted in a reduced carbon burden every year, year over year, since 2005. Statistics compiled by the University of Texas and the Environmental Defense Fund have shown that methane emissions from natural gas production have decreased by 38% since 2005. But then consider this, during the same time frame, the amount of gas produced has increased by 26%. So you would have anticipated that methane emissions would likewise have risen, but during that same time frame, they have fallen dramatically because of those state and tribal regulations that are already in existence. Look, this is about repealing a Trump-era rule. I mean, we get it. We're all in on the inside part of this, but why? Why would we be against policies that provided us energy independence? And the flexibility that we have in the world because of that energy independence, I don't know if I could have defined prior to 5 or 6 years ago what energy independence would mean to us as Americans. But over the last 5 to 6 years, we've all come to understand just what that energy independence has meant. And, Mr. Chairman, we were sitting in this very room and watching the email and the Twitter explode with the knowledge that the Saudis had launched a drone attack. I mean, the Iranians had launched a drone attack on a Saudi refinery, and everybody thought, oh my gosh, better run home, fill up the Prius, because the price of gas is going to go up, and it never budged. That's energy independence. That was when it really came home to me that this mattered, and why we are rushing headlong into giving up that energy independence, it certainly makes no sense. Now, look, I'm old enough to have been on the Energy and Commerce Committee in 2009. We debated a bill called Waxman-Markey. Waxman-Markey was a cap-and-trade bill, which was billed as a climate bill, and Waxman-Markey was important to be able to control the climate. It passed in the House by the narrowest of margins, probably in retrospect was responsible for Democrats losing their majority that year. It never went anywhere in the Senate because they got worried about how negatively this bill had been perceived by the American public. But the actual consequence is that because of advances in the industry and the same state and tribal regulations that you all have described, we are doing better today than we would have done under the regulatory scheme of Waxman-Markey, which really just underscores innovation is a far better approach than regulation. We need to be careful about what we're doing. This is exactly the wrong response to the situation, and I hope people will wake up and see that before it's too late. We don't want to sacrifice our energy independence. I thank you both for being here today. I'll yield back.
Thank you. Mr. Perlmutter.
Thanks, Mr. Chair. Mr. Peters, you haven't gotten to say too much. I'm curious if you have some comments in response to Mr. Carter's concerns that this is going to ruin the oil and gas industry, that it's big government. And I noticed that Diana DeGette is the sponsor of this bill, and I know why she's the sponsor, because Colorado created these methane rules from which the federal government then modeled the methane rules. So, Mr. Peters, do you have any comments?
Thank you, Mr. Perlmutter. Just a couple of points. One is, I think we should really be careful about being confused about emissions here. It is true that carbon dioxide emissions have been reduced substantially because of the switch from coal to cheaper natural gas. But that's a different constituent than methane, CH4. That's not the same as CO2. And the problem with methane is it's such a powerful climate agent that even a little bit of leakage eviscerates all the climate benefit you got from the switch from coal to natural gas, which burns cleaner. But methane is a powerful, immediate, harmful agent, and we've got to get control of that. It is true that there's some overlap between the emission of VOCs and methane, but because of processing, methane is often the constituent left at the end, so it's a different chemical to regulate. It's also the fact that the Trump administration only deregulated parts of the distribution channel, so that they've left unregulated parts that aren't even under VOCs aren't regulated. So that gap has to be closed. Finally, with respect to costs, to the extent that there are additional costs from methane regulation, there's no evidence that those minor costs were passed on to consumers. As Dr. Burgess has suggested, the way prices are set for oil and gas is it's a worldwide system. And there's no evidence that it was passed on to consumers rather than taken out of profits. But I would say also that there are benefits economically to taking this action. And I would just name two. One is, we already know that other countries are suspicious of American natural gas, liquefied natural gas, because they consider it dirty. And although the deal was redeemed, France initially nixed the deal, $7 billion 20-year liquefied natural gas shipments from Brownsville, because they consider our natural gas too dirty. We've got to get this methane under control to be competitive internationally. We also face the possibility that if we don't, we'll be punished with tariffs and border adjustments, because why should other countries take on this burden if we don't? I think if anyone who seriously makes the argument that natural gas should be a bridge fuel in terms of climate has to deal with methane as a constituent. So I think those are some of the responses I'd have. I think this is also finally just is not a fracking ban. It has nothing to do with agriculture or the other things. Clearly this has to do with oil and gas. It's the right thing to do, and has substantial support, not just from foreign oil companies, but from a lot of independent producers. And I think this is in the record, Mr. Chairman. If it's not, I'd ask that the letters be included.
Without objection.
I think that it's fairly widely supported among the industry as well, that they know they've got to get it right, and having different states regulate different ways doesn't help the competitiveness of the industry.
So I would just say, Colorado has been one of the places where we've had tremendous amount of exploration for oil and gas, but particularly natural gas. And we have a lot of coal bed methane in Colorado. We have a lot of other kinds of activity. And I think the purpose for the rules that were negotiated among the environmental groups, the oil and gas groups, and the local governments, particularly that have wells within their jurisdictions, was to minimize methane emissions. So, Mr. Carter, you and I agree on a lot of things. We don't agree on this one. My question is, what effect, I understood the Trump administration rule to have an effect, have an impact, a constraining effect on Colorado's rules that we put into place before the federal rule, which models the Colorado rules, was put into place. And I think that returning and getting rid of this Trump administration rule fortifies Colorado rules. Am I mistaken?
I'm not familiar with Colorado's rules.
They're virtually the same as the federal rules, because we were the first ones to do these methane emission rules. It was negotiated by Governor, now Senator Hickenlooper, along with all of the oil and gas companies and with the environmental community.
Okay, I'm not following you then. If
So my
they're
question-
in place in Colorado,
So my question is, when the Trump administration rule went into place, it limited Colorado's rules. We're going back to where we want to be under what were the Obama rules for methane emissions. Correct? I mean, maybe I'm mistaken as to what the Trump administration rules limited the methane emission rules. And those methane emission rules were modeled on the Colorado methane emission rules. So I want to get rid of the Trump administration rules.
okay.
All right, I'll yield back.
Thanks, Mr. Chairman. I appreciate it. Representative Peters, you brought up a good point saying, why would other countries take up this burden if we don't? Yeah, great point. But I also think you can flip that around, saying, why would we take this burden up if other countries don't? And I know that when we talk about it, we think about European countries and, not to be crass, but their economies are sometimes not even the same size as our individual state economies. I think we need to look at China. So statistically speaking, China is actually the biggest, as we all know, China is the biggest polluter. If you take the emissions, or if you take the pollutants from the United States, the EU, Japan, combine it, China still exceeds it. So just statistically speaking, China is responsible for 27% of global emissions. Admittedly, the United States is second, but we're a very distant second, 11%, and as Ranking Member Carter said, or as Representative Carter said, we're drastically reducing that amount. So Representative Carter, with that, do you have any points on why we would take this burden up and burden our economy if China is going to continue to actually increase their emissions?
Well, that's a great point, and that's one of the frustrating points. It seems like, you know, during this whole discussion about climate change, we all recognize that if the United States of America were to go to zero emissions, we still don't address the global problem. This is a global problem. The impact that we are having with rules like this, with rule changes like this, are going to impact our energy independence and our energy cost with having very, very little impact on the environment itself. And I just don't understand the administration's attack on American energy. What we've achieved in America, becoming now an exporter of energy, folks, we ought to be beating our chest. This is great, what we've done here. And what we've done for the environment, this is even better. I mean, we've been I serve on the environmental subcommittee as well as the select committee on climate change. And you know, we hear about coal plants in China, and they say, well, we ask them, why don't you use the scrubbers? They said, we do. Why don't you install the scrubbers? They said, we do. They just don't use them. That makes no sense whatsoever. And yet how are we reacting to this? We're reacting to this by putting more regulations on small and medium-sized companies. They're going to increase the price to consumers here in America on energy. I just don't get it at all.
Yeah, I think I don't want to focus too much on coal, but there's actually an argument that we're better burning the coal here rather than mining it here, shipping it to other countries where they don't have the environmental standards. Where if we actually mine our coal here, burn the coal here with our scrubbers, it's in totality better for the environment. But I don't want to get distracted. You were talking about consumer prices. I'll come back to that, but I just want to hit the national security aspect of this too, because I deployed to Iraq. I totally get the fact that if we are exporting energy, we are in control on the foreign stage. If we're not, we cede that control to other countries. For example, Russia. From my understanding, Representative Duncan had an amendment basically saying that we should not have that we should not have been behind the pipeline from Russia to Germany. Can you explain what happened in committee and also put it in context with how we're trying to greenlight that, but we actually shut down, not we, but Biden on literally his first day in office canceled the Keystone XL pipeline. Do you just want to discuss that?
Glad to. Again, I don't understand how the United States can support a project like Nord Stream 2 and yet do away with a project like the Keystone XL pipeline. And you know, I go back to what former Secretary of State Mike Pompeo says. And he gives the example. He said, you know, when I was negotiating around the world, knowing that we had energy dominance was such a big advantage for us here in America. I mean, it was something that he was able to take with him all across the world when he was negotiating. And it was a powerful, powerful tool. Who was it? Teddy Roosevelt that said, walk softly and carry a big stick? We got a big stick, but we're doing away with it. We're giving it away. While other countries are not abiding whatsoever. Doesn't make any sense at all to me. This is something we ought to be together on. Look, I get it. I get climate change. I represent the entire coast of Georgia. I've seen the impact that sea level rises has had on our coast, and I understand that. Now, I will disagree on how much of that is man-made, but I do acknowledge that some of it is, and that we can do a number of things. I've always said we have to have adaptation, mitigation, and innovation. All of those things are extremely important when we're talking about addressing climate change. But the policies, it's about the policy, and the policies I just don't get.
So I want to get back to the consumer prices that you mentioned before. Yeah, I don't think people realize it, but when you have cheap, abundant natural gas, for example, people are paying less money for everything. So just in Pennsylvania, for example, your average family is saving about $1,200 a year because we have this natural gas boom in southwestern Pennsylvania. If we have this regulation, what kind of impact will it have on the price of energy for consumers?
In my mind, it's going to have a significant impact. It's going to increase the price of energy. And who's that going to impact the most? The lower income. Lower income people are going to feel this more so than any other class. We need to keep that in mind whenever we're talking. Look, folks, this is important stuff, folks. These policies impact people. They have a direct impact on people's lives. We need to understand that.
And can you also expand upon the fact that this isn't just about energy? Because I often feel like when we talk about natural gas, when we talk about oil, for example, we just focus on energy. But you could have an energy sector that's completely reliable or completely fueled by by clean energy. Okay, you can just say, seed for the argument, we could say we could have everything powered by windmills and you name it. But at the end of the day, we still need the petrochemicals for manufacturing. Is that I mean,
Absolutely, not only manufacturing, but I found it interesting. I can't remember exactly where I was testifying, but petroleum products are even used in surgical masks. What, we're going to do away with all petroleum products? We're going to do away with surgical masks? I mean, we need to stop for just a second and think about just how far-reaching this is.
I mean, you can't even make some pharmaceuticals without petrochemicals.
Oh, no question about it.
As a former pharmacist.
Sure. I'm currently a pharmacist. I'm not giving that up for this gig.
I understand. And don't tell Dr. Burgess, but I'm also currently a lawyer as well.
And I'm licensed as well.
I know. So, Representative Carter, just the key takeaway from your testimony that I'm taking away is that it's a false choice thinking that if we have this regulation that we're going to, basically it's that we can reduce regulation and reduce emissions, and that we can improve the economy. This is a false choice that we're being presented. And if the past few years have taught us anything, we can see a reduction in emission and a growing economy. Do you want to expand upon that?
Absolutely. I couldn't agree with that more. And, I would also submit that, again, the energy sector, the energy companies in this country have done yeoman's work in cleaning it up. I mean, look at what's happening now. It's helped our economy. I have a plant in my district, Elba Island, that at one time was a LNG import plant. It's converted now to an LNG export plant. That's what we want. That's what we want in this country. So, absolutely, I'm proud of what the private sector has done without the heavy hand of government having to tell them what they have to do.
Thank you. I yield back.
Thank you. And thank you for acknowledging that climate change is real, because unfortunately there are a lot of people in your party who won't even acknowledge that. And the previous president himself, when pushed on these issues on a number of occasions, had a tough time acknowledging that. And I just want to say one thing. We've made some advancements in terms of environmental protection over the years, but if anybody thinks that if we didn't have the Clean Air Act or Clean Water Act, that somehow we just relied on these energy companies to do the right thing, that we would have made any progress, I beg to differ with you on that. Mr. Raskin.
Mr. Chairman, thank you. I was going to start at the exact same place. I wanted to thank Mr. Carter also for his comments acknowledging the reality of climate change. And I want to just take it one step further, maybe start with you, Mr. Peters, and come back to Mr. Carter. Are we in a climate emergency?
Absolutely.
And what are the signs of us being in a climate emergency?
Well, I could tell you, speak from the perspective of California specifically, we're in extended drought. We are facing sea level rise. We're facing more intense wildfires, which are both a product of climate change and now a driver of climate change with the production of black carbon. I think if 11% is the right number for American emissions, you multiply that by 9 and you see that the world's really in trouble.
California's lost more than 4 million acres of forest to wildfires, out of control. We've seen record drought in parts of the country. We've seen record flooding in parts of the country. In Arizona, over the weekend, I think it was 115 degrees in the big cities, but pretty much everywhere, somewhere between 100 and 115. We are seeing sea level rise, as the ranking member pointed out. We are seeing collapsing glaciers. We still have people who deny the reality of climate change. We still have people who say it's a hoax from China or from Russia or some other place. But the vast majority of scientists declare that it's not only a reality, but as 11,000 scientists put it in a report in January, it's an emergency. And an emergency means it's something that we need to respond to immediately. Mr. Carter, any thoughts about us being in a climate emergency?
Well, a lot of thoughts. I think if you study this, as I have, you find out that this is very cyclical in nature. We've seen it throughout the years. You know, one of the things that you mentioned about California, about the flooding, about the fires, well, let's be honest with this now. I acknowledge that you're correct that those things are happening, but there are other reasons that they're happening, not just climate change. You know, it seems to be the recipe of the day these days that anything that happens is because of climate change. Well, that's not necessarily the case. The only thing I will tell you is this. I have never referred to this select committee as a select committee on climate crisis. I refer to it as a select committee on climate change. So no, I don't consider it to be a crisis. I think it's cyclical. I think we can have an impact, and we have a responsibility. We do have a responsibility to address some of the things that are happening with our climate.
Okay, that's clarifying. Thank you. So, Mr. Chairman, let me ask you. Do we have to choose between addressing the calamitous consequences of climate change and energy independence?
That's me?
Yeah.
Well, absolutely not. I think, you know, there's been a lot of confusion. I don't want to say that it's intentional about suggesting we're trying to get rid of the energy industry. That's not the case at all. I think in many respects, for us to be competitive in the energy industry, because if trade with Europe is important to us, we're going to have to take care of this kind of thing. And also, I would say, too, that while dealing with climate change is a science project, it's not a jobs program. It will create a lot of jobs. And in fact, if I might just say that the methane mitigation industry, which provides services and equipment to detect, fix, and prevent leaks, has nearly doubled in size since 2017. Mostly small businesses, 65% of job types with annual salaries ranging from $37,000 to $140,000. It's poised for growth, and so there can be benefits from this as well. And I'm not here to defend China. I don't know if President Trump had a position on the pipeline that's referred to from Russia. He wasn't exactly outspoken against Russia in my recollection, but I could be corrected. But there are economic reasons to do this, to protect our industry.
Do you have any doubt that the methane rule that we had before and the other forms of regulatory action we've taken, both in law and in agency rules, have been essential to addressing climate change, methane emissions, CO2 emissions?
No, sir, and I go even further. Mr. Carter said we needed adaptation, mitigation, and innovation. I completely agree. The number one mitigation step we can take is methane. That's the thing that's causing 25% of warming today. And it's not that expensive to take care of.
It's the one that's most amenable to policy intervention.
The lowest hanging fruit is methane.
All right, so it seems to me we have certainly a broad consensus that climate change is real. We have, I think, a large consensus that we're in a climate emergency in the country. We know that regulation works. As the chairman says, without the Clean Water Act, without the Clean Air Act, without aggressive environmental regulation and the success of the environmental movements, we would not be where we are in terms of being able to address this problem. You want to restore the methane rule that was basically demolished by the Trump administration. What was the methane rule that existed under the Obama administration? What did it require the oil and gas industry to do?
Generally required that newer facilities and reconstituted facilities be upgraded to technological standards that were the best available.
So we basically asked them to be at the state of the art, to use best practices. And of course, the last administration had the philosophy, no, let them do whatever they want. This is an interference with their market power to do whatever they want. And we're saying, no, we are in a climate emergency and we're going to ask everybody to adhere to the best practices. And the reason that the states got to the place where they are, which have been praised by some members of this panel on both sides of the aisle, is because they were able to follow the work that the federal government was doing and that the environmental movements have been asking for. Let me ask you finally about the point of the ranking member about the rest of the world. Now, do you agree that America should be acting in unison with the rest of the world to address climate change, or should we be going it alone? And do you think this administration has been recommitting us to working with the rest of the world, or is this administration going it alone?
Of course, that's why we all agree that we should be at the table through something like the Paris Climate Accord. We want to be at the table. We want to be leading the rest of the world, setting an example, and pushing on China, who no one suggests is a good actor in this space. And the only way we can do that is through international engagement and leadership, which has been the history of America and has been what the rest of the world has counted on us for.
And that's why it's a great thing that we got back into the Paris Climate Accords instead of giving our finger to the rest of the world and trying to create a race to the bottom. I yield back to you, Mr. Chairman. Thank you.
Ms. Fischbach.
Mr. Chair, I just have a real, well, hopefully, maybe a quick question, maybe not, but Congressman Carter, you mentioned earlier that what we do here has an effect on people, has an effect on businesses. And I'm very concerned about those small and medium-sized businesses. And I was wondering if you could talk a little bit more, because we regulate from the federal level, and this affects small businesses in my district. And I just think that we should maybe be focused on that and talking about how this is going to affect the real people.
Well, there's no question about it. And you know, I just can't help but have to comment on this idea that we're going it alone. Again, it just appears to me, Mr. Chairman, the only thing we're doing here is this was a Trump decision, and we're going to reverse it. For no other reason, except it was a Trump decision, and we're going to reverse it. Just like what seems to be the majority of all the legislation that we're seeing this year in this session. And you have to admit, there were some good things that were done during that administration. I think there were a lot of good things that were done during that administration. We, after all, did achieve energy independence in this country, and now we want to do away with it. But the impact that you mentioned, that it's going to have the medium and small-sized businesses, you know, it's not going to impact the larger-sized businesses. We know that. They're going to be able to absorb it. We've seen that all throughout our economy. We see that, we talk about all these rules and regulations we're going to put on the big tech. It's not going to impact them. They'll absorb it. It's going to impact those smaller companies. That's what's going to happen here. And these unnecessary regulations are going to make our energy sector less competitive. We talk about being competitive in the world. Well, these kind of policies are going to make us less competitive. That's what is so baffling here. Cheap energy, affordable energy. Who is it most important to? It's most important to the lower class, most important to the middle class. Let's face it, we know that the upper class can afford whatever price they need to pay. But lower class people, they're the ones who are going to suffer. When we do away with competition, we increase prices. And when we increase prices, we're going to increase the burden on those people in the lower class especially.
I appreciate that, Congressman Carter, and I do. I am due on the floor, so I'm going to slip out. But I do want to yield to Congressman Reschenthaler. He had a few more things, and I guess it's his day. It's his day to shine. So.
Well, thank you, and I promised that I would yield to Dr. Burgess. So I'm not sure how this works, but
Do you want me just to yield?
you want to yield
Burgess,
to
yeah.
Dr. Burgess, and he can yield to me.
You can skip over.
Oh, come
Yeah.
on,
All right.
Mr. Perlmutter.
Well,
Thanks. Buddy, thank you, Mr. Carter, thank you for being here. It came up, I guess one of the concerns is not just rolling back this regulation, but then what happens next? Are there new regulations that are teed up and waiting in the wings? And I know it came up during the hearings and markup that although the current administration, when they were running, assured everyone that they were not going to enact a fracking ban, that this could be the initiation down the road to ban this type of activity. Do you share those concerns?
Absolutely. I think this is just the tip of the iceberg. I mean, let's face it. That's exactly what it is. What we're going to see is the use of resolutions like this to clear the way for other sources without establishing that a pollutant significantly contributes to harmful air pollution as a predicate for new regulations. EPA has jurisdiction over 70-plus source categories that span the entire range of American industry. We need to keep that in mind. That needs to be something in our thought process. There's no question about that. I couldn't agree more. This is just the tip of the iceberg here.
Well, and of course, the logical conclusion of a fracking ban, the person who most benefits from that is Vladimir Putin and the Russian oil and gas industry. And I just leave you with that thought. And thank you for being here today.
Thank you.
Back to Mr.
Thank you, Dr. Burgess. I appreciate it. Just
we'll go back to you? Okay.
yeah, thanks. Just 2 quick points. One, on the Paris Climate Accord, this is an absolute farce. We're the only signatory to that entire agreement that actually reduced our emissions. That is never reported, but that is true. Additionally, the biggest polluter, as I said, China, biggest polluter by far. Like I said, if you add up the entire United States, the entire EU, and Japan, China still pollutes more than that. And again, we're reducing our emissions. But back to the point of the agreement, China doesn't need to even start to reduce until 2030. That entire agreement is an absolute joke, and everybody knows it, except the American left. Now, on the other point, I just want to clarify something, Representative Carter. We're talking about methane. I think there's a lot of misunderstanding what this is. The producers are actually trying to capture this gas, because that is natural gas. So I've often described it as trying to regulate how much milk a dairy farmer is allowed to spill. There's already an economic incentive to capture that product. Would you like to expand upon that this is exactly what the producers are drilling for and what is making the manufactured goods that we discussed a moment ago?
Well, that is obvious. The most important thing we could do to help American industry solve the climate problem is get out of the way. That's what we could do. We could get out of the way, and I assure you, look at the progress they've made. Look at the progress we've made here in America. And yet we want to enter, and I can't help but comment on the fact that we want to enter into an agreement in the Paris agreements that we're just going to turn a blind eye to China and let them continue on. We could, again, as I said earlier, we could just decrease our emissions to zero, methane and everything. You think China's going to follow this kind of policy? No, they're not going to follow this kind of policy. You know that. I know that. And what's it going to result in? Decrease in American competitiveness and increase in American price for energy.
Thank you, Representative. I should see if Ranking Member Cole wants to go so we can go 4 for 4. All right, I'll yield back. It was worth a shot.
Yeah, yeah. Let me just say one thing here, one observation. We have gotten away. We have gotten out of the way for too long, and we are now at a point where it is a crisis, whether people want to accept that fact or not. And at some point, in the not too distant future, when we're all gone, the history books are going to be written, and they're going to look back at this moment, whether we did anything. And I mean, what we're arguing about here today, in the scheme of what needs to be done, is so minor, and yet we're fighting over it like it's this big, gigantic deal, when what we need to do to combat the climate crisis is so much more. I worry that we're not up to the task, that we're not going to do what is necessary. And so, Mr. Carter, I paid you a compliment in the beginning for acknowledging climate change. I think I might want to withdraw it a little bit, because I don't think we are on the same wavelength here. I think this is a crisis.
Too bad, Mr. Chairman, it's already in the record.
I know. This is a crisis. It is a big crisis. We're running out of time. We're going to get to the point where it's too late. And the notion that if we just sit back and let the oil and gas industry just do their thing, that they will solve this crisis, God, I just can't believe we're even having this discussion. And even we're just on two different, we look at this from two different vantage points. I mean, I do think it's a crisis, and I think to not admit it, it's a crisis at this point is to ignore the science and to see what's happening all around us. Our coastal areas are being eroded. We see well, I mean, I can go on and on and on. But anyway, Ms. Scanlon.
Thank you, Mr. Chairman. I have to say I'm not a fan of a strategy of seeing if we can out-pollute China is going to get us out of this crisis. Mr. Peters, we had some questions about how reinstating the prior methane rules, which required best practices to reduce methane, how that would impact negatively small businesses. How about how those rules will impact all Americans, my constituents, your constituents, as well as small businesses long range? Aren't there costs to failing to address this?
Of course there are. There are costs to inaction on climate change, and I think people often assume when they make their arguments that we can just keep things the way they are and costs will stay the same. Of course, we know that costs of climate change will be very large, and this part of what we're working against is trying to get ahead of that. And again, just to push back a little bit on the chairman, who I generally agree with, this is the most important single thing we can do today, methane. We could decarbonize. We have more time to decarbonize, but this is the warming curve. And methane is the main short-lived climate pollutant that's driving it. So this is really crucial and a really critical first step. And I think also, as I've explained, there are economic benefits in terms of trade and job creation that we would get back from it as well.
Thank you. And I think, it's great that we've got agreement with the Senate that we need to overturn this rule, but we can't forget about the nearly 100 environmental protections that have been rolled back in other areas, and we have to ask what's the purpose of those rules and who benefits from them, who benefits from dirty air, dirty water, more methane, mercury, coal ash, and mine tailings. I would argue that it's the worst form of corporate welfare, and we need to do better. With that, I'd yield back.
Thank you. I think Mr. Carter's giving me the signal that he needs to leave. Does anybody object to him leaving? You can go.
Thank you, Mr. Chairman. I look forward to a big victory from this.
Thank you. Mr. Morelli.
Thank you, Mr. Chair. I'll be very brief. There are rare times when I agree with Lindsey Graham, but I agree with him on this. He voted in the affirmative in the Senate, so...
I might have to rethink my position.
But I think, frankly, I think what you said, Mr. Chair, is very important. I'll admit that, I know that we have a long way to go, and this is an important step that we need to take. And frankly, I've begun in my later days to worry about my children and my grandchildren, what kind of world they're going to grow up in. And there is a lag here. We will get to a point where all of the efforts of everyone on the planet won't be enough to save it. And this is the existential threat of our age and of all ages, perhaps. So, and to your point, whether we're moving fast enough or not, and I think many of us would agree that we're not, this is something we must do, and so therefore, I'm going to support the resolution. I appreciate Mr. Peters.
Thank you. Mr. DeSagne.
Thank you, Mr. Chair. I just want to thank Mr. Peters. Very, very important initiative on his behalf. And I did want to mention that the fossil fuel industry, of which I have a lot of interaction with, having 4 refineries in the county I represent here in the San Francisco Bay Area, didn't do all these things on its own. It did it because of the U.S. Clean Air Act and the waiver that both President Reagan and President Nixon supported. And that waiver, along with the states that have followed under that, the U.S. Clean Air Act, has resulted in most of these changes, both on traditional pollutants and now on carbon. And then as far as energy independence goes, clearly the move to sustainable renewables is where independence is for the future. And that's where the economy is going, with good paying jobs. So this is an important component. And lastly, as to agriculture, California is regulated agriculture, although it's been tough politically. California produces 50% of the fruit and vegetables in the San Joaquin Valley that the U.S. consumes, but those have been consumed under a business model with fairly aggressive air quality, both on traditional pollutants and now on carbon. So again, it can be done, it's being done, and it's the future of sustainable energy independence in the United States. Thank you, Mr. Chairman. I yield.
Thank you, Ms. Ross.
Thank you, Mr. Chairman. Just a minor point. This bill is also supported by the public health community. It's supported by the American Academy of Pediatrics, the American Public Health Association, the American Lung Association, and many others who have seen the nexus between what methane gas does and deleterious effects on public health. And so I want to thank Mr. Peters for bringing it forward. And with that, I yield back.
Thank you. Mr. Neguse. Okay. We will, well, anyone else have any questions? If not?
Just for the record, make sure
Yes.
we get these. I also want to give some credit to the fossil fuel industry, who's come out in spades in support of this. Sometimes we are critical of them, and we should be when they do the wrong thing, but I think in the record we have a number of letters, social media posts, statements from companies, large and small, in support of the CRA.
They will be submitted for the record without objection. Thank you very much for being here, and you may leave. Our final panel is, this closes the hearing on SJ Res 14. And I'd like to welcome our witnesses to provide testimony on SJ Res 15, providing for the congressional disapproval of the rules submitted by the Office of Comptroller of Currency relating to national banks and federal savings associations as lenders. Representative Garcia and Representative Stile, we are delighted that you are here. I now recognize the gentleman from Illinois, Mr. Garcia. If you have anything in writing, you can submit for the record or summarize, whatever you want to do. The floor is yours.
Thank you, Mr. Chairman McGovern and Ranking Member Cole, members of the committee, for having me here to testify on SJR 15 to invalidate the Office of the Comptroller of the Currency's so-called True Lender Rule under the Congressional Review Act. I am the lead sponsor of the House companion to this resolution, and I've raised concerns about this harmful rule for months. This resolution would put an end to this Trump-era rule that allows predatory lenders to partner with banks in rent-a-bank schemes to evade state laws that protect consumers from high-interest loans. Senate Joint Resolution 15 received bipartisan support, including the support of Republican Senators Collins, Loomis, and Rubio, with a 52-47 vote in the Senate. And the White House issued a statement of administration policy supporting the resolution to invalidate this dangerous rule. I am pleased, if it is the desire of this committee, that we will consider it on the House floor this week. In October of 2020, the OCC, when it was run by a Trump appointee, released the final rule regarding what is known as the True Lender Doctrine. Previously, the True Lender Doctrine was understood to mean that if a non-bank forms a partnership with a bank to make a loan to a consumer, the true lender is the non-bank as long as the non-bank has the primary economic interest in the loan. The OCC's rule flipped this doctrine on its head to say that the true lender would instead be the bank, as long as the bank is listed somewhere in the loan paperwork. That's it. In other words, just on a letterhead. That's all it takes to establish a bank as the true lender, the paperwork. Even if the non-bank holds the primary economic interest in the loan, the bank is considered the true lender. No wonder some call this the fake lender rule. Now, you might be wondering, why does it matter who the true lender is? It matters because non-banks are required to comply with state laws that place limits on the interest rates they can charge consumers on small dollar loans, while OCC chartered banks only have to follow interest rate laws in their home state and can export higher rates to consumers in other states even if they have a lower interest rate. So, by making it easier for banks to be considered the true lender in these kinds of partnerships, this rule creates a loophole for non-banks to evade state usury laws that otherwise would be required to follow. I represent a working-class, primarily immigrant district in Chicago, so this is personal to me. Studies have shown that these kinds of rent-a-bank schemes target communities of color and women-led households in lower-income neighborhoods, small business owners, and veterans by charging consumers triple-digit interest rates that leave them in the spiraling debt trap. More than 400 civil rights, community, consumer, disability rights, faith, housing, labor, legal services, senior rights, small business, and veteran organizations support this resolution. State banking supervisors and credit unions also support this resolution, as does a bipartisan coalition of state attorneys general. I urge my colleagues to support this legislation, which will repeal the OCC's rule and ensure that payday and other predatory non-bank lenders, which are subject to less oversight than loans, do not evade state interest rate caps designed to protect consumers. I urge this committee to advance Senate Joint Resolution 15 to the House floor and request an appropriate rule for its consideration. But before I conclude, I also wanted to take this opportunity to remind my colleagues on both sides of the aisle that June is Pride Month, a time to recognize and celebrate the LGBTQ community's significant contributions to our country, including to the economy, and to stand as allies against lending discrimination. And that's why, as a member of the Financial Services Committee, I support H.R. 1443, the LGBTQ Business Equal Credit Enforcement and Investment Act, led by Representative Torres, which I am pleased will be reconsidered this week on the House floor. It was a shame to see a few Republicans join Democrats in supporting Torres' bill last week after we passed it out of the Financial Services Committee with a voice vote. I sincerely hope that those members will reconsider and vote yes this week, but with or without them, I will be glad to see this important bill pass during Pride Month. With that, I'm happy to answer any questions.
Thank you very much, Mr. Stile.
Thank you, Chairman McGovern and Ranking Member Cole, as well as the members of the committee today, for the opportunity to testify on SJ 15. Democrats' attempt to roll back the true lender rule, I think, really is nothing more than a political rebuke of the previous administration. The CRA arguments that we've heard really aren't based on policy. The bill before us is a politically driven move that will really hurt the consumers that the true lender rule is intended to help. The OCC rule is based on sound policy and risk management principles that emerged during the Obama administration and were finalized last fall. The true lender rule is a policy action that clarified decades of uncertainty. It is an example of the regulator putting people ahead of politics and providing clear rules to protect our financial system and consumers. Let's take a moment from the partisan talking points to break the rule down. The true lender rule determines which entity is the legal, quote, true lender in a partnership between a bank and a third party, such as a non-bank fintech firm. With a clear rule in place, there is legal certainty. This certainty helps to encourage these types of partnerships, which expand the reach of products and services to those who may not otherwise have access to services. When banks and fintechs work together, they can provide consumers and small businesses with greater access to affordable financial products and services, particularly those in underserved communities as well as in rural areas. Bank-fintech partnerships played an important role in providing PPP loans to small businesses, which saved jobs and supported struggling communities during the pandemic. They also helped consumers who are unbanked, underbanked, or have low credit scores safely access financial services. Families and entrepreneurs need access to credit so they can continue to rebuild after the pandemic. Injecting more uncertainty will only disrupt the partnership that support access to credit, hurting small businesses and consumers. If SJ 15 is enacted, more litigation will occur, creating more uncertainty and stifling these innovative partnerships. But those sometimes on the other side of the aisle are willing to ignore these facts to score political points with progressive activists. This is another example of the Democrats rejecting innovation, restricting access to affordable credit, and hurting the very businesses and consumers they claim they want to help. It's bad politics getting in the way of good policy. I'm happy to answer your questions today and might have, and again, I thank the committee for the opportunity to testify. I yield
Thank you.
back.
Mr. Cole.
Thank you very much, Mr. Chairman. To me, the OCC True Lender Rule, which I spent a lot of time talking to my friend French Hill about so I could understand it a little bit better, seems like a good and necessary policy. And in fact, the former nonpartisan acting director of the OCC, Mr. Blake Paulson, who has a 30-year career in civil service, detailed the need for clarity that this rule provides in a letter to the Senate Banking Committee, which I ask unanimous consent, Mr. Chairman, to submit for the record.
Without objection.
Thank you. Mr. Stile, I know you've already given us, I think, a pretty good explanation why we ought to keep this, and frankly, a pretty good explanation why we're moving ahead. It just happens to be a Trump-era rule, but it seems to me pretty clear. So let me ask you a series of questions that I think are sort of yes and no, although you take as much time to answer as you choose, just for the record. Does passing the CRA preclude the OCC from issuing further rules regarding this clarification?
It does, and that's one of the most significant concerns, is it's taking a sledgehammer to a problem that people think may be out there. So in the event that people think that there could be tweaks or reforms to the rule, this would really prevent that wholesale, which is one of the significant concerns of the...
That's true of some of the others we're dealing with, but I think it's a very important point to make. It's a very blunt instrument we're using here. Would passing this CRA further harm small community banks' competitiveness and their ability to provide affordable capital?
Yes, small banks, small community credit unions are often teaming up with fintech companies across the nation to compete with some of our larger banks and need that partnership. In this, if this was passed, they would have a very difficult time making these same partnerships and providing the access to credit to some of these small businesses in sometimes rural or underserved communities across the United
Those
States.
are exactly the kind of financial institutions I represent for the most part, are small community banks, and I've heard exactly that from them. Would passing a CRA further hinder innovation among fintech, financial technical companies that their ability to partner with banks going forward?
Exactly, it would. It would provide additional uncertainty, and as you know, innovation strives to have certainty, and further uncertainty would move us in the wrong direction.
Finally, it's my understanding that under the True Lender Rule, the OCC will still supervise loans national banks make with third-party partnerships, and they'll still have authority to hold banks accountable for consumer protection responsibilities of loan or any other obligation. Is that the case?
Exactly the case.
Yeah, I think this is very much a CRA in search of a problem. It just doesn't make a lot of sense. So with that, Mr. Chairman, I'll yield back.
Thank you. Ms. Torres. Dr. Burgess.
I'll have no questions at this time.
Mr. Perlmutter.
Thanks, I have a couple. Mr. Garcia, I thought both of you explained your positions very well. I thought Mr. Garcia's explanation was very appropriate. Colorado has a 36% cap. 70% of the people of our state voted for it by initiative. Mr. Stile, let's take your proposition that some other states' usury law should control Colorado's, even though 70% of the people in my state said, no, this is the limit. Under the True Lender Rule that that Mr. Garcia is trying to revoke, is what happens when a state with no usury cap has that bank in it, but the non-bank or the fintech or whoever it is that is originating the loan goes to that other bank. So Colorado's 36% limit no longer takes effect? Is that what happens?
Well, I think there's a challenge of conflating the valid when made with True Lender. And so True Lender is simply providing that clarification to fintech companies as to who originated the loan and who funded the loan.
So you said it makes it simpler, but if the rule is where the loan is originated, controls the limit on the lending rate. I mean, that's a pretty simple rule. So if a company in Colorado says, we want a loan to Mr. McGovern, and Colorado says, okay, that's fine, but you can only have an interest rate of 36%, but no, Nevada has 122%. I don't know what they have. Now, all of a sudden, Nevada, their interest rate supersedes Colorado's, as I understand the true lender rule. Am I wrong?
You're still under the supervision of the OCC. You're under the National Banking Act, Section 85, and so you're not completely outside of broader controls. You're making it clear and providing clarity as to where that loan originated from a true lender standpoint.
Yeah, so I guess that's the point, saying that the loan really originated in Nevada, not in Colorado, even though it's a Colorado individual, Colorado company where I go in and they're the ones making the loan. So I guess I hear you, I understand that it may seem simpler in some respects, but it completely disregards what the people of Colorado said would be the limit in Colorado for interest rates that a consumer might experience. Mr. Garcia, let me ask you a couple questions. I mean, what is it that has driven you to want to revoke this true lender rule?
The true lender rule would do away with states' abilities like Colorado, like red states like Nebraska, Arkansas, South Dakota. In Nebraska, similar referendum, binding referendum was passed. If that rule remains in place, it would prevent those states from being able to regulate against usury, even with spectacularly popular binding referenda like the ones you experience in your state and in places like Nebraska. States like Illinois and California have similar 36% rate caps. This would prevent them from being able to implement them. That's why this rule needs to be repealed. And on the question that was raised previously regarding the OCC's ability that it would tie the hands of the agency in the future and prevent them from ever taking any future action on the topic, according to the nonpartisan experts at CRS, passing a CRA joint resolution of disapproval does not eliminate a federal agency's ability to provide guidance on rulemaking in the future on that issue. As you know, CRS clarifies that an agency may reissue a rule related to the rule that was disapproved or within the same policy area, so long as the new rule is not substantially similar to the disapproved rule, so it doesn't tie their hands forever or in every significant way.
And I appreciate that the agency may want to introduce a new rule, and this doesn't completely tie their hands, but I guess what I was thinking, and Mr. Stahl, you may be right, that this is a matter that needs more clarity than it has, but I would suggest that that's our job. That if we want to pass a law that says the loan is originated where the person, the borrower, sits and where they went into an office and they signed the loan papers, that's where it's originated, or it's originated with the entity that's providing all the capital, which might be New York City or San Francisco or some other place, then that's our job to determine where the loan actually is originated. So I don't think it's a dead end, Mr. Cole, that we can't deal with this, but it doesn't necessarily have to be within the agency itself. I think both of you have done a heck of a job explaining it. I come down certainly on where Colorado is, where 70% of our people said 36 is it, period. Now, whether that works or doesn't work, whether it limits lending in Colorado or not, the people spoke. And, we don't need some agent in the OCC telling us, well, your people don't know what they're talking about. So I think that's kind of over the top in terms of, nannyism or something, I guess is where I'm coming from. So I appreciate both of you being on the committee with me, and you've both done an excellent job explaining the positions that you are supporting. So with that, I yield back.
Thank you, Mr. Reschenthaler.
Thank you, Mr. Chairman. Representative Stow, would you like to add anything to what Mr. Perlmutter was just saying? Would you like to clarify your position?
I just think it's important to make sure we're just defining the difference here between valid when made and true lender. I think there's an easy issue to conflate between the two. I think that this true lender rule actually provides a lot of clarity, and I think a lot of the discussion I think actually falls onto people's concerns with the valid when made rule.
Thanks, Mr. Chairman. I ask for unanimous consent to enter into the record a Bloomberg article titled "Black Business Owners Turned to FinTech to Get U.S. Pandemic Aid."
Without objection.
Thank you, Mr. Chairman. Representative Stow, from my understanding and in the article I just referenced, Black-owned businesses turn in much greater proportions than white-owned businesses to FinTech loans. Is that correct?
Yes, I assume the article that you just submitted references the Federal Reserve study that indicated that 25% of Black-owned businesses utilized a FinTech partnership between a FinTech and a bank to access PPP loans, really demonstrating that the ingenuity coming out of our FinTech services here in the United States that are able to operate on a nationwide basis are able to provide loans, again, to underserved communities as well as rural areas in the United States in a similar manner.
So we hear a lot about the social justice warriors talking about disparate impact with communities and quote-unquote systemic racism. This actually would have a disparate impact in lending and would create, by the article you just said and the impact it would actually create systemic racism. Is that correct?
Well, FinTech companies really have an opportunity to provide access to services for those that may not have easy access to a brick and mortar financial institution. So you can envision that in some urban communities in the United States. You can also envision that in rural communities in the United States. And many of the FinTech companies that we're seeing that are evolving in the space, relying on the certainty that the true lender provision provides, relying on that certainty, they're innovating and making it such that almost everybody who has a smartphone has access to financial services products in their pocket. And so if you have a friend, or you can jump on the internet, you're going to have access to financial services products regardless of whether or not you have close proximity to a brick and mortar financial institution in the area that you find yourself living in.
Would the gentleman yield?
Absolutely, Mr. Perlmutter.
Thanks. I appreciate that, and I think you're both right that FinTech uses capital that may be coming from some other place. And in terms of PPP, the capital was coming from New York or California or Texas or some other place to small lenders in Colorado, no question about it. But this is a different question. This is about the interest rate being charged, and I don't think I'm conflating it. That ultimately, and it may have been a mistake that Coloradans chose to set a 36% limitation, and we may not be able to get loans as a result of that. But that's the point, and I appreciate the gentleman for yielding to me.
No, thank you, and I do have a bill idea that I'd like to run past you after this hearing. I think we could find some common ground. But Representative Stow, just the bottom line on this line of questioning is that if we repeal this, it will have a disparate impact on Black-owned businesses, as the statistics show, that they will be hit harder than white-owned businesses.
We definitely saw Black-owned businesses utilize FinTech companies in a greater manner than almost any other demographic group, according to that Fed study. For the financial services, that innovation is what's so critical to make sure that we're getting people that are either unbanked or underbanked access. And if I can, just to provide one additional comment, I think it's relevant that the true lender rule does not preempt state law.
Would you like to expand upon that at all before I yield back?
I think some of this is just going between the true lender and the valid when made, and I think that's just an important point to try to hit.
Sounds good. With that, I yield back.
Thank you. Ms. Scanlon. Ms. Fishbach.
Thank you, Mr. Chair. Congressman Stile, maybe I was looking at in particular, the community banks, and I know that Congressman Reschenthaler was asking a little bit about maybe minority-owned businesses, things like that, and maybe you could expand a little bit and just kind of talk on that same way, what kind of effect it would have on those small community banks that are so prevalent in my district.
So the certainty that this rule provides is really critical for the innovation in the fintech companies. And so what's happening right now is we have a lot of small community banks, a lot of small credit unions that want to provide financial services products. But to do that, they're competing, of course, against the big banks, right? So I can imagine a small community bank in Janesville, Wisconsin, where I live, or maybe a small community bank in Minnesota, in your district, that doesn't have millions and millions of dollars to put into a financial services product to compete against, say, JP Morgan or Bank of America. And so what this allows is our local community credit unions, local community banks, to team up with a fintech company to provide that service. And so that partnership is what's so critical. And that certainty that this rule provides is what provides that access for our local community banks and credit unions to really compete with some of the big players.
And so, Congressman Steil, what kind of effect will it have if this legislation?
If this legislation went through, we'd have additional uncertainty, you'd see additional lawsuits, and you'd see a reduction in innovation. And so one of the great things that we've seen in the past handful of years is great innovation in the space of our financial services products, really giving individuals access that are either unbanked or underbanked, and as well as providing additional tools for people to use. And in a moment of time like the pandemic that we just recently went through, when PPP was being pushed out to make sure that employers and employees were able to continue and go forward, we saw a large number of businesses, small businesses across the United States, often those that are working with community banks and credit unions, be able to rely and utilize fintech services. And interestingly, under the Federal Reserve study that your colleague, Mr. Reschenthaler, submitted into the record, what we saw was a disparate impact where, in a positive way, right, where a larger percentage of black-owned small businesses were utilizing these financial services to be able to get PPP loans, to ultimately be able to keep their employees intact during what was a really tumultuous period of time as we went through the pandemic.
And Congressman Stiles, I guess what you could say then, it is going to make it more difficult for people in rural Minnesota who rely on community banks or rural America, period, to access the kind of credit and the kind of capital that they need to keep the economy going. Is that an accurate statement?
These fintech companies are providing competition, which is driving down, which is increasing access for individuals if they're in rural Minnesota or if they're in an urban area. It's going to increase access, and that competition is going to bring rates down and provide people the services that they need.
Thank you. I yield back.
Mr. Morelli. Mr. DeSagne.
I have no questions, Mr. Chairman. I yield back.
Ms. Ross.
Thank you, Mr. Chairman. Just wanted to point out that the progressive activists who are the veterans of this country oppose this bill. I just want to read from one of the statements from one of the veterans organizations, that support this bill. One of the veterans organizations that supports this bill.
Thank you for clarifying.
We're concerned that the final rule hurts all consumers, including veterans, Gold Star families, and unactivated members of the Reserve and the National Guard by allowing lenders to charge interest rates of 179% or higher that are not subject to state interest rate caps. And so, again, this is a good bill, and I'm from a military state, and I stick with my veterans.
Thank you. Mr. DeGoose.
No questions, Mr. Chairman.
Thank you. Any other questions? Hearing none, we thank you both for being here, and you're free to go.
Thank you.
Thank you very much.
Anybody else wishing to testify on HJ Res 15? Hearing none, that closes the hearing portion of this. And before I go any further, I want to ask unanimous consent to insert on the record a statement of administration policy in support of H.R. 239, the Equal Access to Contraception for Veterans Act, and in support of H.R. 1443, the LGBTQ Business Equal Credit Enforcement and Investment Act.
Without objection.
Without objection, okay. The chair will now entertain a motion from the distinguished gentleman from New York, Mr. Morelli.
Thank you, Mr. Chairman. I move the committee grant H.R. 2062, the Protecting Older Workers Against Discrimination Act of 2021, a structured rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Education and Labor or their designees. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 117-6, modified by the amendment printed in Part A of the Rules Committee report shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides that following debate, each further amendment printed in Part B of the Rules Committee report not earlier considered as part of the amendments en bloc pursuant to Section 3 shall be considered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, may be withdrawn by the proponent at any time before the question is put thereon, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule provides that at any time after debate, this chair of the Committee on Education and Labor or his designee may offer amendments en bloc consisting of further amendments printed in Part B of the Rules Committee report not earlier disposed of. Amendments en bloc shall be considered as read, shall be debatable for 20 minutes, equally divided and controlled by the chair and ranking minority member of the Committee on Education and Labor or their designees, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in Part B of the Rules Committee report or amendments en bloc described in Section 3 of the resolution. The rule provides one motion to recommit. The rule provides for consideration of H.R. 239, the Equal Access to Contraception for Veterans Act, under a closed rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Veterans Affairs or their designees. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule provides one motion to recommit. The rule provides for consideration of H.R. 1443, the LGBTQ Business Equal Credit Enforcement and Investment Act, under a closed rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services or their designees. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 117-7 shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions of the bill as amended. The rule provides one motion to recommit. The rule provides for consideration of S.J. Res. 13 under a closed rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Education and Labor or their designees. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. The rule provides one motion to commit. The rule provides for consideration of S.J. Resolution 14 under a closed rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce or their designees. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. The rule provides one motion to commit. The rule provides for consideration of S.J. Resolution 15 under a closed rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services or their designees. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. The rule provides one motion to commit. The rule provides that House Resolution 485 is hereby adopted. Finally, the rule provides that at any time through the legislative day of Friday, June 25, 2021, the Speaker may entertain motions offered by the Majority Leader or a designee that the House suspend the rules with respect to multiple measures that were the object of motions to suspend the rules on the legislative days of June 22nd or 23rd, 2021, and on which the yeas and nays were ordered and further proceedings postponed. The Chair shall put the question of any such motion without debate or intervening motion, and the ordering of the yeas and nays on postponed motions to suspend the rules with respect to such measures is vacated.
Can you just read that one more time? No, just,
With gusto.
Thank you very much. You heard the motion of the gentleman from New York. Any discussion or amendments? Mr. Cole.
Thank you very much, Mr. Chairman. I would like to move the committee provide an open rule for H.R. 2062. Mr. Chairman, May 24th of 2016 is the last open rule that came to the House floor. That was during the Republican-controlled 114th Congress. That means it's been 1,855 days have passed since the House considered a bill under an open rule. And my Democratic colleagues now hold the record for the longest time in the modern Congress without an open rule. Now, I have to say, in all fairness, we we gave you a big target there.
You did.
But I want you to know you've now surpassed it. So each day that we go on, you'll add to your lead. And I raise this actually much more seriously than just, I think we have to have at some point, and this may or may not be the appropriate time or venue, a serious discussion about whether or not we ever have open rules again. I say that as somebody that got here, as you did, Mr. Chairman. I came a little bit later than you, but we used to have open rules on all the appropriations bills, every one. My Democratic friends took that away. We tried to restore it when Speaker Ryan, but then we went away from that too. And we did that because we were afraid of got-you amendments. But I argued against this in conference at the time. I told our individual members, you're making a big mistake because you're actually limiting your power as an individual member because you're afraid of casting a tough vote. You're afraid of getting up and voting on, I don't know, it was a Confederate flag vote or something. I can't even remember what it was. But it was something that literally the chairman got up and said, this will not survive the conference. Just vote with me here. We'll strip this in conference. Not going to get there. And we had too many members that were afraid of it. I suspect you have had conversations that are similar to that in your caucus. So I raised this just and offer this to make the point, and maybe you and I can have a separate discussion about this, or you can talk to your leadership, because I think the Congress is really at a very serious point, inflection point here, about whether or not, open rules are just going to be a relic of the past. And that's based on a lack of trust. It's based on a lack of cooperation sometimes between chairman and ranking members. I don't care who's in the majority at any given point in time. I'm just telling you the culture in terms of being able to have an open amendment process is slipping through our fingers at a very rapid rate. And I would say we bear equal responsibility. I'm not trying to make a partisan point here, but I am making an institutional point that we ought to think about. When we go over 1,800 days without an open rule on anything, and you had to go 1,855 to break the record. So, and we held the record. So, again, that's not meant to make a partisan point, but it is to make a point that sooner or later, we have to decide whether this is a tool we're permanently taking out of the toolbox. And while I think it enhances the power of the majority and the leadership, no matter who uses it, I think it really diminishes the power of the individual member on both the majority side and the minority.
Would the gentleman yield?
I certainly yield to my friend.
So, Mr. Reschenthaler and I on the Modernization Committee, we are talking about open rules and the fact that we haven't had them for quite some time, and does that affect the power of the individual member? And I think we're coming to the agreement that it does, but the fact that either, you can just run out the clock by changing a comma on this amendment and changing a period on that amendment, and then doing a gotcha amendment on the next one, and just swamping the process, I think led both parties to say this isn't working either. So I think there's got to be some kind of agreement in the background between the caucuses that it's really, that the open rule is for real amendments but who's going to judge that? But it is something we're discussing as, does it affect the institution? And I yield back to the
Well, thank you very much, and I'm heartened that you're having that discussion. I genuinely am, and I think that's a good thing. I think probably we ought to have that discussion more broadly, and then probably, as you implied in your remarks, certainly needs to happen at the leadership level, because I really do think this hurts individual members. This hurts your ability to go down, and it does it on both sides. Some of the most inconvenient amendments I've ever seen were presented by members in the majority against their own majority. They can't do that anymore. It's not just the minorities amendment that gets weeded out. It's amendments that and my friend and I would have had these kind of issues to some degree in the war powers debate. Where again, it didn't matter which side you were. These are kind of knotty, sticky issues. So anyway, I offer this in that spirit. I don't expect it to be accepted, although I'd be prepared to be surprised and thrilled. But this is something that we're going to try and raise in this capacity maybe a little more frequently, that we need to at least start thinking about it. And I don't know where the appropriate test case would be or whatever. And again, that probably is a discussion would be above my head at the leadership level. But it's something we need to start thinking about because, again, I just see this slipping away. And I will tell you, the institution is fundamentally different than it was when I arrived in many, many ways. But I would say the individual member is fundamentally less empowered and effective than that member was when I arrived. And so I think that ought to concern us all because, again, I don't think just the minority suffers from this. I think members on both sides suffer from this. So with that, yield back.
Mr. Chairman, if I could just speak to the Cole amendment briefly. Mr. Cole and I came in at the same time. We did appropriations bills throughout the summer, and you'll recall those were 5-day work weeks, open rules. Everyone got heard on their amendment. We all had to vote on them, but it really gave a rank and file new member a feeling of ownership of those appropriations bills. I'd actually worked on them, been down there for the debate on amendments, perhaps participated, moved to strike the last word, and I recognize it's sometimes inconvenient because it does make the clock seems to stop on the floor as well as in the Rules Committee, but it is an important part of the legislative process, and it is a way for virtually every member, regardless of their station, regardless of whether they're in leadership, regardless of whether they're in the majority or minority party, it gives every member a chance to be heard. And that is something that we're lacking now, and I think I think we're a less effective body because of that. And then I always used to point out to Chairman Sessions when he was chairman, and Paul Ryan, and even John Boehner before Speaker Ryan, that every now and then you just ought to let an open rule go through. Everyone can remember how awkward it is to have these things go on for days after day after day, and perhaps people won't ask for them every time. But it is we've lost something by not doing that.
No, I appreciate that. You know, it would have been helpful if you voted for a couple when we offered them, but I would just...
I was there.
Yeah, I know. But I would just say that, you know, to clear up the record here, I don't think we've been in charge for 1,800 days.
No.
Right, so that...
That's not the record. It's been that long since we've gone.
Oh, okay.
You now have gone longer than any other majority.
All right, yeah, right. But we haven't surpassed on the most closed rules yet in a particular session, so that's the distinction that...
We've gone a longer time without an open.
Yeah, but I just say, you know, look, I appreciate, and we should have this discussion, and I'd love to have it. The bottom line is, the reality is, I mean, in addition to the pandemic, which we're now coming out of, is that we can't even get a unanimous consent request to bring up a suspension bill. And I mean, I think one of the things that's changed is that, you know, I don't recall when we were doing open rules, but when Republicans were in charge and when Democrats were in charge, that there is such a focused group of people who seem not interested in legislating but disrupting. And if we could somehow figure that out, and people have the trust that we would bring things to the floor where people would debate issues, you know, that were really intended to improve the legislation, no matter where you came from. You know, maybe we could get to that point. I don't know. I mean, so much trust has eroded, and I'm not saying anybody on this committee, because I think if we were in charge of the universe, we could do things very differently. But I mean, I think there is a real issue that it would essentially replace the filibuster, and I hate to say this, but I don't think every member in this chamber is committed to the institution as everybody on this committee is. And but I think it's a discussion that we should have. I worry about that all the time, but this is really, I mean, there are a lot of issues that we need to work out, and maybe now that we're back meeting in person, we can all go to therapy together and figure this stuff out,
May I just conclude.
Yeah, I think Mr. you want to?
Oh, certainly not, I'm my
Reschenthaler?
friend.
No, I'm just imagining you and I doing like one of those trust falls.
Trust me. I'll catch you.
You're making this more and more unlikely, Mr. Reschenthal. Let me just end with this. Look, I don't have any doubt about my friend's sincerity in this, because we've served together on this committee a long time. We've worked together on serious issues. You're a serious member, and I think you're very interested in having people express their opinions. And I agree with every concern that you've voiced, because I've seen them, and I've seen them on both sides. And I lost this argument in my own caucus when we had people that were too afraid to vote on open rules. And, we had people pushing forward amendments in some cases on the Democratic side and then voting against the bill that they got their amendment into, knowing that that amendment would then cost us votes because people were afraid to vote for the bill, even with the assurance. I mean, I told one guy, you can get up on the floor and say, I'm going to vote for this bill, but I'm saying if this is still in this bill when it comes back here, because it's coming back, then I'm going to vote no. I mean, you can give yourself all the protection you want. You can always develop the process thing. But again, and part of this is modern campaigning and got you campaigning, where we pull one little thing out of context. So it goes beyond just the members here. It actually goes into the larger political culture. But anyway, I brought this up in this
No, I
way
appreciate
today,
it.
simply to have this discussion. I know we'll have it on other occasions, and but I think in some way, and I'm glad that my friend from Colorado, my friend from Pennsylvania are on the Modernization Committee and thinking about these things, because I think it's a very important topic as to whether or not we're going to be a genuine Congress in the way I think our founders intended us to be, as opposed to a parliamentary system, which is what I think we're evolving into, before our eyes. And that wasn't what our founders had in mind. That's not the way we operated for most of our history, and I think we're poorer for it. And I think it plays into the polarization that's out there now. Open rules also create some odd and interesting alliances on the floor that break down some of the partisan rigidity. Regional alliances, those odd cases where libertarian Republicans and progressives are on the same page on everything from big tech to free speech issues or what have you. So anyway, with that, offer my amendment and offer those thoughts, and I thank you for indulging us in the time.
You heard the gentleman's amendment? All those in favor say aye.
Aye.
Opposed, no?
No.
Opinion of the chair, I think the noes have it.
I think they probably do, but I want a roll call.
Clerk will call the roll.
Mrs. Torres? No. Mrs. Torres? No. Mr. Perlmutter?
No.
Mr. Perlmutter? No. Mr. Raskin?
No.
Mr. Raskin? No. Miss Scanlon? No. Miss Scanlon? No. Mr. Morelli? No. Mr. Morelli? No. Mr. DeSaulnier?
No.
Mr. DeSaulnier? No. Miss Ross? No. Miss Ross? No. Mr. Neguse?
No.
Mr. Neguse? No. Mr. Cole?
Aye.
Mr. Cole? Aye. Mr. Burgess?
Aye.
Mr. Burgess? Aye. Mr. Reschenthaler? Aye. Mr. Reschenthaler? Aye. Mrs. Fishbach? Aye. Mrs. Fishbach? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk, report the total.
4 yeas, 9 nays.
Amendment is not agreed to. Are there further amendments?
Mr. Chairman.
Mr. Reschenthaler.
Thank you, Mr. Chairman. I have an amendment to the rule. I move the committee make an order amendment number 8 offered by Representative McLean to HR 2026. This amendment clarifies that an Americans with Disabilities Act mixed mode of claim under the bill may not rely solely on the fact that an employer engage in an interactive process with an employee or a job applicant to determine a reasonable accommodation. Mr. Chairman, simply put, Congress should not discourage employers from reasonably accommodating ADA-covered individuals. Because of that fact, I would urge my colleagues on this committee to adopt my motion, and with that, I yield back.
You heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Reschenthaler amendment. All those in favor say aye.
Aye.
Opposed, no? No. Neither chair, the noes have it. Liaison nays have been requested.
Mrs. Torres? No. Mrs. Torres? No. Mr. Perlmutter? No. Mr. Perlmutter? No. Mr. Raskin? No. Mr. Raskin? No. Ms. Scanlon? Ms. Scanlon? No. Mr. Morelli? Mr. Morelli? No. Mr. DeSaulnier?
No.
Mr. DeSaulnier? No. Ms. Ross? Ms. Ross? No. Mr. Neguse?
No.
Mr. Neguse? No. Mr. Cole?
Aye.
Mr. Cole? Aye. Mr. Burgess? Aye. Mr. Burgess? Aye. Mr. Reschenthaler? Mr. Reschenthaler? Aye. Mrs. Fishbach? Aye. Mrs. Fishbach? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk, report the total.
4 yeas, 9 nays.
Amendment is not agreed to. I think I just pointed for the record that we do have one bipartisan amendment on this, 2 Democratic amendments, and 2 Republican amendments on this bill, so I think it's fairly balanced. But in any event, further amendments? Hearing none, the vote is now on the motion from the gentleman from New York. All those in favor say aye. Aye.
Aye.
Opposed, no. No. Opinion of the chair, the ayes have it.
Mr. Chairman, on that, request recorded.
Recorded vote has been requested.
Mrs. Torres? Mrs. Torres? Aye. Mr. Perlmutter?
Aye.
Mr. Perlmutter? Aye. Mr. Raskin? Aye. Mr. Raskin? Aye. Ms. Scanlon? Ms. Scanlon? Aye. Mr. Morelli? Mr. Morelli? Aye. Mr. DeSaulnier?
DeSaulnier, no. Aye.
Are you okay?
DeSaulnier, aye.
Yeah,
Mr.
you got it.
DeSaulnier? Aye. Ms. Ross? Aye. Ms. Ross? Aye. Mr. Neguse?
Aye.
Mr. Neguse? Aye. Mr. Cole? No. Mr. Cole? No. Mr. Burgess? No. Mr. Burgess? No. Mr. Reschenthaler? No. Mr. Reschenthaler? No. Mrs. Fishbach? No. Mrs. Fishbach? No. Mr. Chairman?
Aye.
Mr. Chairman? Aye.
Clerk, report the total.
9 yeas, 4 nays.
Motion is agreed to. And Mr. Morelli will handle it for the Democrats.
And Mr. Burgess will handle it for the Republicans.
And I think that's it. So without objection, the committee is adjourned. Thank you all very much.
Chairman.
Yeah.